Can I just say something about Andrea?
Good morning, everybody. I need my crypto queen crown this morning, but unfortunately couldn't get it out of the vault. You know, too many new cars and piles of gold coins in the way. Yeah, no, sorry for my bad jokes this morning. But yeah, for those of you coming over from X, just confirmation. Yes, the hackers are back. The hackers are back, and it's a little bit alarming this time because they got past my 2FA somehow. Not quite sure how that happened. Last time when I got hacked and I was able to get the account back, changed everything and set up the two-factor authentication. But yeah, somehow they were able to bypass that. So I am currently, again, locked out of the account. We're going through the whole report to Twitter cycle again, wait for their support to come in and do something about it. So last time it took about 2 weeks. Not really expecting them to move any faster this time. So yeah, avoid the X. There's nothing to see there at the moment. But otherwise, hey. How's everything going, guys? It's bright and early here. Real bright and early. Get a little sip of the old coffee. But things are good. Hey, I'm excited for Mickey. Hey, Mickey. Hey, Mickey. Mickey Stines, guys, back to court. It's been a minute. We were doing our very first live stream of Mickey Stines court last time when the court session lasted approximately 5 seconds. Everybody went up to the bench and then court ended out of the blue. And it was because the defense had filed that motion to disqualify the judge. So he couldn't hear anything that was pending until that got resolved and our hearing went away. But this hearing today should hopefully make up for a little bit of that because, of course, it has been quite a while. This case has gone on for a minute. Like, my Lord, we're already in the many years point, right? I need to even check the date. What date did he shoot the judge? Okay, it's 2024, so I guess it's not quite 2 years yet. But it's, yeah, it's been a minute and it's been a good several months since we were in court on the case. And so there's a lot that's waiting in the wings to get resolved here. Kind of current status of the case, it's in pretrial. We don't have a pretrial date set yet, or a trial date set yet. And there are several pending motions. It's gone through some kind of preliminary stuff. We know that he is pursuing an insanity defense or a guilty but mentally ill, which is this kind of peculiar resolution that they have in Kentucky, where they can find you guilty but send you to prison to get mental health treatment. He is, as the result of these allegations that he has a serious mental illness, he is also asking the trial court to strike the death penalty, which is kind of an interesting one. Kentucky is, again, rather unique. Not many states have laws that prohibit the death penalty for people who have serious mental illness. Most states and kind of the federal standard under the Adkins case is intellectual disability. So what we used to call mentally retarded. Not allowed to execute intellectually disabled people under the 8th Amendment. But that does not extend, constitutionally speaking, to serious mental illness. And so there's lots of arguments made frequently to expand that. We saw that in the Kohberger case where Ann Taylor argued that just kind of applying the reasoning of the Adkins case, the reasons why it's not fair, appropriate, decent to execute somebody with an intellectual disability, that a lot of that same reasoning, she argued, applied to autism. And so she argued that Brian's autism diagnosis should take the death penalty off the table. That was, of course, denied. Won't be appealed up because of the guilty plea. But so that's the kind of arguments that get made. Talk about that a lot in capital litigation, where they kind of argue around the edges in the gray areas of the existing law, kind of push for certain things to be expanded, certain things to be ratcheted back. But as a matter of federal law, it's not there at this point. People who are seriously mentally ill are executed all the time under the Eighth Amendment as we interpret it right now. Well, I shouldn't say all the time because, executions are not really that common, but nevertheless, no legal impediment to them. But Kentucky state legislature decided differently. So they passed a law that makes certain diagnoses exempt from the death penalty, basically. Just kind of a policy conclusion that if you suffer from one of these illnesses, your culpability is diminished. There's, less, I guess, voluntary, participation. It's like less that you're evil and more that you're sick. And so that's going to be interesting because, of course, the implication if you're asking for this relief is the suggestion that Mickey Stines has one of these diagnoses. But we don't know what his diagnoses are at this point. We know that he has gone through a psychological examination with the state forensic hospital that they have there in Kentucky. We know that he likes the result of that report because he wanted it to be unsealed. Kentucky law seals those reports as a matter of law. He wanted it unsealed. The judge said no. And it seems also that the prosecution wants a second one. They want a second one. I've been trying to find the brief on the prosecutor wanting a second one. Our access to the legal filings in this case is a little bit intermittent, I guess is the best way I can put it, because I kind of have to rely on the media to get it and report it. Kentucky themselves are not real friendly about providing court records to people not in Kentucky. But so I don't know what their argument is for a second psychiatric evaluation. There doesn't seem to be anything in the statute that provides for it. I would kind of like to see that. But obviously, Mickey likes the one he has, wants the whole world to see it. State doesn't like the one he has, wants him to have to get a second one. This pretty strongly implies the one he got is pretty favorable to Mickey. And so this is very interesting to me because that's been kind of the big swirling question around the mental health defense is it legit? Is it legit? And it's because of the circumstances leading up to the murder when he was being deposed and he was claiming to have California encephalitis, which is extremely rare, weird thing to say you have. But also just what a thing to make up. If you're going to make up a mental illness, how do you come up with that one? Claims he has it, seems implausible. At the same time, after he's arrested, there's all these reports from the people that interacted with him from the jail, doctors at the jail, everything like that, talking about how he was psychotic. He was in a, delusional type of state. So is there a there? That's kind of the $1 million question. And so the interesting thing about this motion to take the death penalty off the table is that it seems like they're going to have to put up what's there in terms of this mental health issue, this mental health diagnosis, because you need to show that in order to qualify for this particular relief under the statute. So that's part of what will be on the table, if not today, at least at some point. On kind of a related note, we've got his motion for bond. Way back when he had asked for the indictment to be dismissed and to set bond. Obviously, the indictment did not get dismissed, but the judge said, you do get to have a bond hearing. We need to decide first if you are bailable, meaning do you qualify for a bond in the first place? And the reason why is because he's charged with a capital crime. We still don't know. Are they going to pursue the death penalty? Are they not? But it is technically eligible. And so Kentucky law, like many states, provides for no bail in capital cases. But they have this qualifying language that says something to the effect of, except where in cases where the proof is strong and the presumption great. It's something like that. So it includes this kind of weighing of the evidence in whether or not you get a bail. Like, is there a good case against you? If there's not a good case against you, even if it's a capital case, you can get a bail in Kentucky. And so there's interplay with that particular issue as well with these defenses that he's claiming, because, hey, if he's got a lower level of culpability, or if he, is potentially got a strong case for insanity or guilty but mentally ill, then might entitle him to bond. So that is another avenue where we might get to hear a little bit more about what is there. What is going on with this condition that led him to, he says, do what he did. What's the last thing? Oh, the last thing is the change of venue. And the change of venue I almost forget about, because, Lord, that has been pending for so long. I went back and found the motion on this one. Let's go ahead and bring it up. Because this was back in August of last year that this got filed, and it's just been sitting there the whole time. I don't think, let's see, this is small. I don't think I can make it bigger like this, because if I make it bigger, we can't read it, but hopefully it's big enough to read. Anyway, this is their petition for change of venue. Kentucky is a little bit unusual. Again, we've talked about this before, in that they allow the prosecution to move for a change of venue if they think they can't get a fair trial in the county where it's set. Normally, it's up to the defendant in most cases, but Kentucky lets the prosecution make that determination as well. So they are arguing, it's a fair point. The scene of the crime happens to be the courthouse. Yeah, where all of this is going to happen, where these jurors are going to come in, where, everybody works, everybody knows the guy. They're going to be walking through the halls where these events took place. Like, normally in a criminal trial, they give you advisements like, don't go to the crime scene, don't do your own investigation. There's just a possibility that people might be looking for something, some kind of information about the case from the crime scene that they're not getting from the trial. And then if they were to rely on that, if that influenced their decision, that would be a problem. You're supposed to only base your verdict on the evidence that's presented in court. So having this just kind of general access to the crime scene, to a lot of the personnel and the everybody who knows everybody part of this this institution, yeah, that's unusual, and that is potentially a little bit of a challenge. Also, they were both public officials who were voted upon by the residents of Letcher County to serve in their respective roles. Every eligible voter in Letcher County either had a reason to vote for or against the defendant and the victim at one time. The preconceived opinions as to the character and ability of these two men is likely to irreconcilably prejudice both the Commonwealth and the defendant if this trial takes place in Letcher County. Yeah, the public figure aspect of it does potentially complicate things. Maybe not to a huge degree. At least not over now, because court is in session. Getting close to things happening over there. I mean, public officials do get charged with crimes. Certainly not unheard of. Don't always have to change venue just because, somebody's a public figure. I think it maybe just gets a little bit more complicated in this case, though, because of the smallness of, the venue. It isn't just that these are public figures. It's that they're public figures in this context where you're probably a lot more likely to have closer connections. The kind of campaigning where you go out and you doorbell and you talk to all of the constituents and things like that. So the governor gets charged with a crime. It's pretty unlikely the governor has shown up on your doorstep, knocking on your door. Hey, I want to tell you about what I want to do for the state, things like that. But way more likely in a small community like this, that type of contact might take place. And then just, of course, the whole, pseudo incestuous kind of relationships. When you've got all the court staff, you've got the sheriff staff, you've got everybody that they know, you've got all their little, friendship networks, professional networks, and everything. That complicates things. So I haven't seen. I mean, maybe it's out there, but just hasn't been published since we're kind of dependent on the media to share the court filings with us. I haven't seen that the defense ever filed a response to the request, but maybe they did. I really don't know. I expect that the defense wants it here in Letcher County. There's a reason, once again, why the state wants it gone. The defense hasn't asked to move it. They like it there, and there does seem to be reason to think that Mickey is kind of popular here. He was just fairly recently reelected, if I remember right, before the shooting took place. He seems to have been a pretty popular guy, pretty well thought of. A lot of people, from his staff, the jail, and everything like that, kind of coming to bat for him a little bit in this case. Backing up the mental health deterioration and strange behavior, and encouraged him to try to get help, things like that. It's very quiet. How's our sound here?
Morning, ladies and gentlemen. We're here in regards to Commonwealth.
Super quiet.
Mickey Stines, 24 CR 204. If Mr. Steele, if you would identify the Commonwealth and who's here on behalf of
Judge, I would. Defense counsel like your order. In the meantime, John Jackie Steele, or Commonwealth Attorney, 27 Circuit Special Prosecutor.
Prince Dallas is the Attorney General Special Prosecutor on behalf of the Commonwealth.
See if I can get a boost.
Your Honor, I'm Sheriff Stines as counsel. I just thought I'd introduce myself. My name is Chris Reinhardt. I represent Kimberly Mullins as administratrix of the estate of Kevin Mullins, as well as her personally and officially. Thank you, Your Honor. I'm on mute.
Okay. See if I can.
All right. Mr. Barber, if you identify yourself and who's the counsel table with you.
Chris Rumpy had just 1 second on the local box, sir.
Let's see if I can get this a little louder.
Sure. Jerry Bartley on behalf of Mr. Stines, also co-counsel Ms. Kerry Bartley, as well as co-counsel Mr. Jim Cox. Your Honor, there's members of my staff that they're intended to seat in the gallery and not
Sure.
otherwise at the table.
Should be fine. All right,
Can we seat it, Your Honor?
please.
Thank you.
All right, since we last met, we've got some motions that are still outstanding. We want to try and address some of these, and start looking at heading towards hopefully getting this matter set for trial. First, there's a pending motion for a hearing pursuant to KRS 532.135 to exclude the death penalty at trial. The Commonwealth has filed no notice of aggravated circumstances up to this point. My understanding, after briefly speaking to the parties and chambers, is that we're going to hold that motion in abeyance pending the resolution of any other potential evaluations, and then if the Commonwealth files notice, readdress that. Is that correct, Mr. Bartley?
That's correct, Your Honor, with the caveat we discussed that obviously will be in ample time so that it wouldn't affect trial strategy.
Absolutely.
Or any, if there's any additional experts as a result, such as mitigation. Your Honor.
Absolutely. And that'll be set pursuant to the rules. Next, the Commonwealth's given notice regarding a criminal responsibility examination. Mr. Steele, do you want to address that?
Your Honor, Ms. Ramsey will address that issue.
Your Honor, the Commonwealth, as the court noted, has filed a notice requesting a second mental health evaluation to be conducted by a private expert retained by the Commonwealth, Your Honor. It's our position that the Commonwealth is entitled to that. The defendant has filed notice pursuant to Rules of Criminal Procedure 8.07, subsections 1B and 2B, and accordingly, the Commonwealth is entitled to rebut any defense related to insanity or any evidence going to issues of guilt or punishment related to mental disease or defect. So it's the Commonwealth's position that we are entitled to a second evaluation. We're not requesting funds from the court, Your Honor, for that to be done by our private expert and for Mr. Stines to submit to that evaluation, Your Honor.
And I've read the pleadings regards to that. Mr. Bartley?
Just trying, the criminal rules, I think, are pretty clear that in fact we have to give notice in terms of our intention to introduce the defense of insanity. I hate that nomenclature, but it still persists, so I'll use that for purposes of today's hearing. However, we've given that notice. We gave that almost as soon as we got into the case.
Look out,
We
kitty.
identified Dr. Drogan as our intended expert. At this point, he's not completed, and we'll comply with the rules in terms of doing so. But the rules of criminal procedure that were cited in the notice, I believe, are 807. And under that rule, Your Honor, I agree that they are entitled to have Mr. Stines evaluated. And that's why they filed the first notice and they asked.
We're going to go ahead and switch.
They could have gotten any expert they want.
All right. We're going to switch over to law and crime here, see if the sound is a little better.
And under that rule, Your Honor, I agree that they are entitled to have Mr. Stines evaluated. And that's why they filed the first notice and they asked for the court to send the KCPC. They could have gotten any expert they want at the beginning. I mean, like they said, they've got the money. They can send them wherever they want to go. KCPC is the Commonwealth's, as they've always made very clear, that is their facility. And they availed themselves of that facility. And he waived his Fifth Amendment right as to an examination. It's a quid pro quo. If you put mental health at issue, then I believe that the Commonwealth has a right to have him examined. And he's done that. And I look in reference, Your Honor, to KRS 504.
There we go.
The section cited in my in the civil rule as well as in RCR it's 807, Your Honor. It says that they're entitled to an evaluation. And I believe under the rules of statutory interpretation, the first thing you look at is plain language. To me, "and" signifies, and 504 is adopted by reference into the rule that's cited for the notice, Your Honor. And I believe that "and," with its ordinary meaning, means singular. And I think the concern is multiple. First of all, if you look at the case that I cited there, it is Benjamin v. Commonwealth, 266 Southwest 3rd, 775. And in that case, they were looking at a defense request for another evaluation. And they said, basically, if you don't like the result, that's tough. And it's an even playing field I would urge the court to hold here now. Again, if you file notice of insanity, I think there's a limited waiver of your Fifth Amendment rights, but the cases make it very clear it's limited. It's limited in scope, and the statutes address what should and should not be brought in. But the remedy, if he were not to have complied with the first examination, would have been that the court could do anything up into striking his entire defense. But in this instance, Your Honor, we willingly, readily presented him to their expert. That was their expert that they asked him to see. And now what they're asking the court to do is make him go to another. Now, what I suggested in my response was that they could very well, do I believe they can hire another expert and pay them to come in and testify? Yes. I don't think there's anything I can do to stop that. It's the evaluation that I think is the invasive part, Your Honor, that would subject him to yet another waiver of his Fifth Amendment. We are now 2 years out. You know, the first evaluation will be much more relevant. But if they want to get there and get another opinion and have somebody come in and say, Drogan and Dr. Allen, there's reasons not to believe that testimony, I can't refer to it, Judge, but that testimony that the court's aware of, then I think they can. And they can get there by simply having them review the procedures by KCPC. They have all the data. They have all the data that is there. And they can provide that to an expert. He can look at that and he can opine that the previous opinion is incorrect or impeach it, Judge. I'm trying very hard not to breach the reference, Your Honor. But I think that's it. In the civil context, there has to be, you're looking at, is there something flawed in this examination? I mean, I think if their motion said, when we see in KCPC, they rushed and did it, and it was incomplete, it was this and that, they've had the evaluation, and we agreed that they could share that with whoever they potentially want to look at it. Then I would say today, if there was some evidence they could put on for the court that this was flawed, of course, we would cross that and ask to subject it to proof. But I believe that's what they should have to do, rather than just have him again waive his Fifth Amendment right, go to a state expert again. He was compelled to do it from the jail twice. He was compelled to do it at KCPC, Your Honor. And I think that, you know, my question also becomes is, where does that stop? I mean, at some point, how many examinations do we send him to? If this is if this expert, whoever it may be, were to agree with both our expert and Dr. Allen from KCPC, do we get another one? And I think that's exactly why the courts have said that the waiver of the Fifth Amendment in this context should be limited. And I would ask the court to find that he did his part. He understood the quid pro quo. We discussed that on the front end, but what we didn't discuss was a quid pro double quo. And so I'm asking the court they can still get their expert to rebut. I understand there are cases that talk about they get an opportunity to rebut it, but there's nothing that should compel him to once again waive the Fifth Amendment right and go see an expert government mandate, Your Honor. They can get to the same point without compromising that again.
All right, resolve.
Yes, Your Honor. The Commonwealth's position is that it's clear here, there is no statute, rule of criminal procedure, or case law that would serve as precedence for this court saying that the Commonwealth is limited to a single evaluation of the defendant as to criminal responsibility.
That's not a good argument.
There that says that. Instead, the Commonwealth has the burden of rebutting these defenses that the defendant has indicated he intends to present. The Commonwealth's position is that the reliance on the Benjamin versus Commonwealth case is completely misplaced. That was a very different situation. In Benjamin, there was a defendant who was asserting both competency issues as well as criminal responsibility. In that case, an evaluation had already been conducted. The defendant had not until the day that trial began articulated specific reasons for a request for funds for an additional evaluation. At that time, the court said, no, your request isn't timely, it's not necessary. And then an appellate court in reviewing that said, due process was not violated, Your Honor. This is markedly different. We're not here asking the court for funds. We're certainly not requesting a second evaluation the day that trial begins. We don't even have a trial date at this point, Your Honor. So the Commonwealth feels that our request is valid and that a second evaluation should be conducted of the defendant. Additionally, the experts at KCPC, I believe the defense has referred to as the state's expert. Well, Your Honor, if the Commonwealth is not conceding that the defense can call an expert from KCPC who evaluated the defendant at trial as their expert, but if they intend to do so, then certainly that expert would not serve as the Commonwealth expert. And therefore, we would be entitled to obtain a private expert to evaluate the defendant in this case. As far as any waiver of Fifth Amendment concerns, that is explicitly addressed in the rules of criminal procedure, specifically under 8.06 and 8.07. It says that any statements made by the defendant in the course of these examinations cannot be used against the defendant unless they choose to use those examinations and evaluations to their benefit. So that is addressed directly in the statute. That argument is completely without merit. So we would ask that the
Well, that's
Commonwealth be
weird.
allowed to have their private expert conduct an evaluation of the defendant.
Ms. Martin, respond.
Yes, sir. That's completely the inverse. I agree. There's nothing out there that says they can't, but there's nothing out there that says they can't. And so my point is this, Judge. I mean, so it should be limited to the intention of the rule. The intention of the rule is to give a fair play. He waived that right. It should be limited, Your Honor, in terms of whether the statements are privileged. That blanket prohibition of the statute is riddled with exceptions. And I'll be very surprised. I'll be extremely shocked if we get to a trial and there are not statements from any of the examinations that come in. It's riddled with exclusions, Your Honor. I ask the court not to compel Mr. Stines to, once again, Judge produce evidence that is potentially used against him, Your Honor. Again, you can accomplish both goals by letting them have the prior evaluation of the raw data from that examination, and they could still have someone to rebut them. As far as whose witness it is, they asked that the court order he see their expert. That was the first notice, and they said their expert was going to be at KCPC. Now they're asking for an independent expert. They were both Commonwealth's expert. The fact that I may call them is irrelevant. I mean, they weren't the courts. I didn't ask for it. So obviously it's their witness, Your Honor. So regardless of who calls them or whatever that may be, we didn't ask to see Dr. Allen, but we do want to hear what he has to say at trial, Your Honor.
All right. Ms. Dawn, if the court does order another evaluation pursuant to the Commonwealth's request, what kind of timeline are we looking at?
Your Honor, we don't foresee our expert he's located out of state in Indiana, but fairly nearby.
Okay.
Of course, there would be travel time and we would accommodate his schedule, but we're not expecting any significant delay, Your Honor.
Okay.
Your Honor, if I may,
Sure.
in terms of if the court does permit the second
Sure.
expert, Your Honor, then what we're asking is that, once again, Dr. Drogan be permitted our
Absolutely.
original expert. But Your Honor, I think it's very prudent, and it's not without precedent, actually, with Dr. Allen, that the KCPC doctor be there as well, because if they're going to rebut and be critical of what he did, Your Honor, then I think it is only fair that we should be able to have him observe so that he can respond to the criticisms that they place on the KCPC exam.
Okay. All right.
Your Honor, if I may, the Commonwealth does not have any objection to Dr. Grogan appearing. We would have an objection to Dr. Allen.
If I do order it, I would have obviously no issue with Dr. Grogan being present. I am gonna have to look at whether or not Dr. Allen being present would be appropriate in regards to it. I've not made a ruling yet in regards to another evaluation, but I do think the court inherently, under RCR 807(1)(b), has the authority to order the second evaluation, but I want to review the pleadings and I will get an order out to the parties shortly in regards to that, because I do want, timing wise, if this is going to be done, to get that moving. So, next issue before the court.
Your Honor, can I have one more thing, Your Honor? In
Sure.
terms of that, if the court does in fact order that examination, then I believe that we're entitled to discovery as to fees paid and as well as
Sure.
ours as well. I just
Yeah,
want to make sure
absolutely.
we get that discovery as well.
That'd be no problem at all.
Thank you.
All right. Next, let's go ahead and, Mr. Bartley, you've got pending bond motion.
Your Honor, I'd ask that Ms. Bartley take that issue with court.
Ms. Bartley, go ahead.
Yes, Your Honor. Carrie Bartley on behalf of Mr. Stines. Judge, the court has issued an order basically granting us the evidentiary hearing that we requested. It's the Commonwealth's burden to put on proof that the defendant's guilt is proof is evident, or the presumption is great of his guilt of a capital offense. We don't believe that they would be able to do that. Cases under Markham v. Broughton say that essentially where conflicting evidence creates a plausible basis for self-protection, which is not necessarily what we have here, or a reduction out of the capital range, that the Commonwealth can't meet that burden. And so, Judge, what we would ask is just for the court to hear the Commonwealth's proof, and then if necessary, then we have some brief proof that we would like to put on as well.
All right. Mr.
Judge, we discussed this previously, and come with this ready to proceed, we're going to submit to the court the recording of the shooting that day.
Okay,
It was played, it was introduced,
it's part of the record. I
it's
know.
part of the record, but we're going to submit it to you
All right.
for your consideration.
Go ahead.
And Your Honor, we would object to that. I believe it's, the Commonwealth has to put that on. The rules of evidence apply. The court has rules of evidence apply. We don't think the Commonwealth can lay a foundation.
Everybody knows
for
he
that.
shot him.
Video today. I don't think they have a witness to testify to that today. And so I don't think that it's appropriate for the court to take it into consideration today if they can't put on any evidence as to.
All right, that objection to the rule. All right,
Judge, if I may just say on that issue, and I'll be very brief, this was introduced in the preliminary hearing. Foundation was laid. Same counsel was present during that, and no objection to it being.
And Your Honor, at that point, if I may, the rules of evidence do not apply in a preliminary hearing. The rules of evidence do apply today under Young, the Young case. Judge, court cited that in its own order. And so I would, again, vehemently object to the record to this being introduced without any foundation being laid at this particular hearing where the rules of evidence do apply. And, Judge, I just don't think it's appropriate. I think that, it sort of flies in the face of applying the rules of evidence, or for that being the court's ruling, that those rules apply, Judge, if we allow the Commonwealth to put in proof without having any testimony to that effect, and without any witness being here to be subject to cross-examination as to that issue.
well, just,
Judge, under Rule 1101, applicability of rules, it says, subsection D, rules and applicable rules other than with respect to privileges do not apply in the following instances. Number 5, miscellaneous proceedings, without reading all those, it says, and proceedings with respect to release on bail or otherwise.
Yes, Your Honor, and again, I can reference to the court's bond order, where the court specifically references to the Young case, Judge, that says that the subject to the rules of evidence, Young v. Russell, upon request for bail, the defendant may testify, call witnesses, etc. So the rules of evidence absolutely apply. It's in the Young case. It's black letter law, Judge.
all right, the court's going to overrule the objection. The facts surrounding September 19th of 2024, which is the basis of this action. There is information in the record previously which transfers from the district court case pursuant to the indictment. I do believe that it would be appropriate for the court's consideration. So anything else in regards to, anything else you want to review on bond?
Yes, Judge, I have a witness if I may.
Absolutely.
Defense would call Ms. Sherri Stines.
All right, Ms. Stein?
Oh,
And Judge, if it's okay, I'd like to stay at council table. I think that there's an issue with the podium that
That'd be fine.
kind of goes up and down.
Sherri Stines being called as a witness.
Stay right at the podium. All right. If you will, raise your right hand and be sworn. Do you swear?
Mom
affirm
or
the testimony
wife?
you give you the truth, whole truth, nothing but the truth?
I do.
All right, ma'am, if you would state and spell your name for the record.
Sherri Stines. Sherristines.
Ms. Bartley, may I ask?
Yes, Your Honor. Ms. Stines, again, Sherri, just tell us where you're from, where you live.
I'm from Neon, Kentucky.
Okay, is that in Letcher County?
Yes,
Do you know Sean Mickey Stines?
yes.
What do you call him?
I call him Bubby.
Bubby? Okay.
Yes, he's biologically my nephew, but my mother and father raised him.
Well, that was my next question. What's your relationship to him? So
Yes,
you're his aunt, is
Yes.
that correct?
yes.
All right. Now,
Bubby.
how close of a relationship do you have with Mickey now?
Very close.
And has it always been close?
Yes.
Okay. How much older than Mickey are you?
I'm 62. He's getting ready to be 45.
Did you ever live with Mickey?
Yes.
And is it okay with you if I call him Mickey? I know you call him Bubby.
Yeah, I
but
call
don't
him
think we're that
Mickey,
close
yeah.
yet, so he may not like that. I want to ask you about the date September 18th of 2024. Do you recall the events of that day?
Yes, it's day stayed all night with me.
Okay. And you said that's the day he stayed all night with you. So you
Mhm.
saw Mickey that day, is that
Yes. yes.
right? Okay. And about what time that day did you see Mickey?
It was late in the day when he came by the house. It wasn't dark, but it was later in the day.
Okay. And when he showed up to your house, did you know he was going to stay the night with you?
Yes, he told
Was it common for Mickey to spend the night with you?
me. No.
Why was he going to stay the night with you that night?
I think it was going to be just to let his wife and daughter rest, where he had been such a nervous wreck and wasn't sleeping.
Okay.
Yeah.
So you said he was going to let his wife and daughter rest. Now tell me, why couldn't they rest?
Because he couldn't sleep and he was wiping the floors, and I guess he was aggravating them.
Okay. Now, did you talk to his wife or his daughter about that at all?
No, not that night. He was at the house, so I didn't. I tried not to get in that.
When he came to your house, had he called you before and said, I'm coming over?
I can't remember if he called and said he was coming or not, but he knew he could come anytime he wanted. It's like his second home.
Okay, so you said he came by later that evening.
Yeah.
And when he came by, did he bring anything with him?
He brought a bag, and in it he had those little tuna creations, and turned out it was like melatonin gummies and some over-the-counter Benadryl.
And did he have anything to say about why he had Benadryl or melatonin gummies?
Well, he hadn't been sleeping, and it's like he hadn't slept in 7 days and nights. And he had went to the doctor, and they had told him to take the Benadryl and the melatonin to help him rest.
When
I'm assuming it was that day or the day before. It was very close.
So he had gone pretty close in time to when he
Yeah,
You don't know for sure the day.
yeah. No,
Okay. And the doctor recommended to him to take melatonin and Benadryl to
right.
try to get some sleep.
Over the counter.
Not the tuna.
And when he got to your
It was
house,
all him.
what did y'all do first?
And we just basically sit around, watch TV. I went in and I fixed us a little bit of supper. We ate. He didn't eat a lot.
What'd you make?
Pork chops,
Uh-huh.
like green beans,
No, I'm
potatoes.
going to object this time. I don't understand the relevance of what we're on in
The
regards to-
menu. We're fascinated.
I'm gonna overrule the objection that that's.
Are we gonna add trichinosis
Yes, sir.
into the mix?
So Mickey got to your house, you ate some dinner, and then what did you do? What happened?
Just sit around for a minute. He was real fidgety, walking from one door to the next. it's kept getting later and I take oxygen at night. So I sat in my recliner at night and take my oxygen. So I give him a bed in my house. I have an extra bedroom. Told him to go lay down. He goes in, he lays down for a few minutes, and then before I know it, he's right back in the living room with me, and he's carrying a pillow. And I said, "Baby, can't you sleep?" And, no, I just can't. And he would take like melatonin and Benadryl, sit there, keep his phone in his hand. And he was watching his security cameras, watching around his house.
So he's watching the security cameras at his house?
Around his house, yeah.
At his house, okay.
Yeah.
And you said, let me go back to the melatonin and Benadryl. So he's taking melatonin and Benadryl. Did he take that at the same time?
Yes.
Do you know what kind of Benadryl or melatonin it was? How many milligrams, anything like that?
I don't know, but I've still got them at home in the bag he had them in.
Okay. So about how many, if you had to guess, or if you know, don't guess, if you know, how many melatonin, how many Benadryl did Mickey take that night?
I'd say about 3 to 4 Benadryl and about the same with the melatonin gummies.
And did those seem to have any effect on him at all?
No.
And so did he sleep?
No.
You said he was on his phone looking at the security cameras,
Mhm.
and he was looking at the area around his house.
Yes.
Did he have concerns about what was going on around his house?
Oh yeah, he was paranoid. He thought somebody was going to be around his house and, you know, like, I guess do something, bother something.
What was he concerned about in terms of someone being at his house?
He was worried about Lila and Caroline, his wife and daughter.
He's worried about his wife and daughter.
Yeah.
Did he say anything at all? Did you get any indication of why he would be worried about his wife and daughter?
No, but I knew he was under a lot of pressure, a lot of stress.
Did he mention that there had been any specific threats to him?
Nothing specific, but I just, you know, you could tell the way he acted, it was bad. He was horrified. He was scared to death.
He was scared to death.
Yeah.
You don't know what he was scared to death of?
No, but, you know, I had my theories, but
Well, let's not talk about theories.
that's my theories, but that's not what it was, you know, that I know.
Okay, so you said you were up all night with him,
Yes.
and at any point did he go anywhere?
No, but he did try to get me, the daughter my mother adopted a child. And at the time she'd been at the doctor's office, had a headache, passed out, done MRI, she was in the bed. Well, Mickey at one point tried to get me to ride up by his house, just to check around his house and make sure it was all right. And he wanted me to leave her in the bed. Anybody that knows Mickey would have never suggested you leave a junior in high school in the bed by itself and it's dark outside to go check around somebody's house.
He wanted you to go with him to check on his home.
Yes, his home.
Had there
Yeah.
been something that made him want to go out there?
There was a guy walking down the back street behind his house and you could see his legs. And he was just walking down the alleyway, but it was enough to freak him out.
What did he think was going to happen, if you know?
Just my opinion, I think he thought they was going to like circle around by his house.
And do what?
I don't know.
He said he was concerned about Caroline and Lila.
Mhm.
And what was it about Caroline and Lila? Did he mention anything specific to them, what he was afraid of?
He was just afraid somebody was going to hurt him.
I heard.
Yeah.
Now, you've known Mickey for a long time.
Mhm.
His whole life?
Yeah, he brought him home from the hospital.
You familiar with his normal behavior?
Yeah.
What's Mickey like normally?
He's a jokester. He likes to laugh, play. He helps people a lot. He's a good guy. Hyperactive. He goes out and does stuff without you having to beg him to do it, you know, or ask him. If he sees you need help, he'll help you.
Was his behavior that night consistent with his normal behavior?
No. He acted different. I've never seen Mickey act like that.
You had to
What about when he had California
describe
encephalitis?
how he acted in one word, what would you say?
One word, he was kind of psychotic.
Kind of psychotic.
Did he ever sleep?
Not while I was with him.
What time did he leave your house?
He left the next morning. Now I didn't look at the clock, but it was between 8 and 9.
Between 8 and 9?
Yeah, something like that. But I didn't look at my clock, so but it was early.
That's early.
At that point, had he slept at all?
No.
Did you talk to Mickey anymore after he left your house that day?
Yes.
And let me back up. Was that September 19th of 2024?
Yes.
You talked to him again after that?
Yes.
How many times?
I think he tried to call me once, a voice call, but then he did FaceTime me once from the courthouse.
From the courthouse?
Yeah.
About what time was that?
2:49 maybe.
2:49?
Yeah.
Okay. And that's PM, I assume.
Yeah, yeah.
If I showed you a screenshot from a video, and Judge, this is going to be a screenshot from the video of the Commonwealth is into this. If I showed you a screenshot of a video, do you believe that you could identify the person on the phone?
Okay.
Judge, if I may approach you.
Sure.
Jackie.
So he FaceTimed her. I'm pretty sure this is
Are you wanting to
after.
mark that for the record?
No, Your Honor, I'm just.
Okay.
Is this after the shooting?
I'm sorry,
Why now?
say that again. Now,
To me,
you believe that's you?
yes.
And is that roughly the time? Let's see, I'm gonna go here. Apologies. Judge, if I can approach again.
Sure.
I have a timestamp screenshot.
No, it's slightly
of the
before. 2:52.
1438 is, I'm sorry, 1448. And that's you on the video?
Yes.
Okay, and that's the FaceTime call that Mickey made to you?
Yes.
And is that about the correct time that you recall him
Yeah.
FaceTiming you? On that FaceTime call, what did Mickey say?
This is like minutes before.
Well, like I said, my mother and daddy raised him, so he had a name for my mother. He called her Mommy Bones.
Mommy Bones?
Mommy Bones.
Okay.
And he called me and he said, Sherri, and I said, what? He said, let me speak to Bones. That's what he called Mommy.
Did you let him speak to Bones?
She'd been dead 2.5 years. And I said, what? And he said, let me speak to Bones. I said, Bubby, where you at? Are you at the office? He said, let me call you back. I got a bad connection. I said, well, okay, call me back. He said, love you, bye. And that's the last time I talked to him.
That's the last time you talked to him.
That's the last time I talked to him.
Did you find that call concerning?
Yes.
Well,
He asked for my mother twice. He was with me when I had to unhook my mother from the ventilator. So he knew she was gone. It was me and him together had to unplug it. So he knew she was gone.
again, has Mickey ever acted this way in the past?
No.
Did you eventually find out what happened at the courthouse that day?
Yes.
When did you find out?
It took about till I found out for sure about half an hour.
What was your reaction to that news?
My knees got kind of weak and my mouth fell open and I cried my eyes out.
Is that something that you could ever imagine that Mickey would do?
Never in a million years would I have ever thought that Mickey would even discharge his gun, let alone do something like that.
Has he ever been violent?
No.
Has he ever been angry, mean, rageful? Any of those things?
You know, everybody gets angry, but I've never seen him violent.
Do you know if he's ever discharged his weapon?
Not that I know of.
Did you have an interview with the police after this all happened? Did you tell them that day what you're telling us today?
Yeah.
You said that you still have the Benadryl and the melatonin at your house.
Mhm.
The police come to your house?
No,
How'd you talk to them?
on the phone.
On the phone?
Yeah.
How many times did you talk to them?
Once was like an interview conversation, and then I think I may have had to call them back once after that because I remembered something. They told me if I remembered anything to call them back, but I can't remember specifically what it was.
Okay, but they never came out to the house.
No,
They never collected any evidence.
No.
They didn't take the medication.
no.
You kept in touch with Mickey at all since he's been in jail?
Yeah, I wrote him a bunch at first, but now it's down to just like FaceTime, and I'll go up and FaceTime, with his wife, daughter, something like that. Not as much as it was, but it's as much as I can.
You know how he's doing?
He's not doing good at all.
When you say that, what do you mean?
I mean, he's always had to take antibiotics every day of his life. He's got a really bad infection in his head. And it's not just looks wise, it's painful, and it's getting on his face. His head's got these, it's hard to lay his head on pillows. He's in a lot of pain, is the point. This tick bite he got has always caused him a lot of trouble.
Tell me about that. You said he got a tick bite?
Yes, they
Tick
call it
bite.
California encephalitis or something like that.
There it
Do
is.
you know what that is?
He went to and from the hospital so much, and they kind of acted like it was a mystery illness. Like, oh God, we can't find it. Just go home and take Tylenol. But it just, his blood pressure would be up, it'd be down, up, down, and it was he just looked pitiful. In that hospital bed, his feet hanging over him, them acting like he wasn't sick, and they come to find out, run the test, that it really was something.
And what was it again?
It was from a tick bite. I think they call it California encephalitis.
California encephalitis?
Yeah.
And do you have any idea? I know you're not a doctor, but aside from just being tired, being in and out of the doctor's office and things like that, do you know in any way how that affected Mickey? What symptoms he had, anything like that?
No, it had a lot to do with tightness in his head and stuff like that, I think.
Tightness in his head?
Yeah,
Okay. Did it have any behavioral symptoms?
I don't know.
You don't know. Okay. And that's fair. That's fair.
But now he does have really high blood pressure. He was born with a heart murmur. And he's just always had a lot of health problems, chest-wise. Heart, lungs. He had a hard time breathing. And it seems to be his health going down.
Health's going down.
Yeah.
Has Mickey lived in Letcher County his whole life?
Yeah.
Yeah. Born and raised. You brought him home from the hospital.
Yeah.
Yeah. Do his wife and kids live in Letcher County?
Yes.
Yeah. I think you already kind of told us when he was sheriff.
Mhm.
What kind of sheriff was he?
He tried his best to help everybody if he could, to give everybody a chance. Tried to help turn their lives. He tried to help their families too. They were having a hard time with their kids. He tried to help.
Mickey got any criminal record?
Nope.
You know if Mickey has a passport?
No.
Has he ever been out of the country?
No.
Ever been on an airplane?
No, I'd have never heard the end of it if he had.
As far as you know, what's his relationship like with Caroline and Lila?
They seem to get along great. I mean, everybody has trouble,
Sure.
But can't live with each other, can't live without each other,
Now, if Mickey were to get out on bond, does he have a place to go?
Yes, always.
Where?
Me or them.
They still willing to take you in?
Why, yeah.
You willing to take him in?
Yeah.
Judge decides to give him a bond and he's able to make that bond. You think he'd comply with the bond condition?
Yes.
Would he show up for court?
Yes.
Would he take off and go to Mexico?
No.
Bing, 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 bing. It's mosquito-borne illness. It's not from ticks. It's very strange. Yeah, these are your common tick illnesses that they look for. Alpha-gal has something to do with like you can't digest meat after that or something. There's something weird with alpha-gal. Very weird diseases you can get from ticks. But California encephalitis is not one of them. That's from mosquitoes. Typically only infects children.
You said
Extremely
you'd
rare.
written Mickey some letters and things from jail. You ever FaceTime with him?
Yeah.
And do you do that just you and him?
I go up to his wife and daughter's house and then I FaceTime with him up there
How often do they FaceTime with him?
every day.
Every day? Okay.
Yes.
Now, you said, obviously we've gone over how he was acting the day before this all happened, the day of. Since you FaceTime with him, since he's been in jail, what, close to 2 years now, right?
Yeah.
Have you noticed any of those paranoid type of behaviors at all? Does he seem like he's pretty much back to baseline
He seems pretty,
even?
He looks really bad, but I mean, he acts kind of calm now.
So he looks bad?
He looks bad, but it's really, he seems like he's calm now. He's not in the state he was in like this.
Fair enough. Judge, I think
What's the Seroquel? I don't know if
You
it's called
cross.
Seroquel, but
Yes, Your Honor, I just have a few questions for you.
that'll calm a
Ms. Stines.
person.
Let me make sure I understand this right. So Mickey wasn't acting right the day before to the point where you were concerned.
Yeah, he was acting,
And did you call anybody?
no,
Did you call his wife and say, what's wrong with Mickey? Is something's wrong with him?
no, he was,
And the next morning when you got this phone call, you didn't call anybody. You didn't call anybody at the sheriff's department, did you? And say, hey, something's wrong with Mickey. Is he there?
no,
Did you? And you didn't call his wife that day either, did you? And say, Mickey's not acting right. You asked about bones. Is something going on with Mickey? You didn't call her either, did you?
no. When he called and asked for my mother,
Yes, ma'am.
that was right before it happened, so I didn't have time to call
I
anybody.
think you said you had 30 minutes before you realized what had happened. See, in that 30-minute window before you realized what happened, you didn't call anybody, did you?
It had already happened.
Right, but you didn't know that.
No,
Okay, so you never called anybody between that
Sure
time and the
didn't.
time you found out.
no.
And you've spoken very highly of Mr. Stines, but my understanding is that he's concerned for his wife and daughter. Is that right?
Mm-hmm.
And he left them at home alone. Went to your house. Is that what you're saying?
Mm-hmm.
He didn't stay in the driveway. I mean, they were upset because he's walking around and keeping them up. He didn't go to the driveway and step in the car, did he?
I don't know if he did that or not.
He left and went to your house, correct?
Yeah, he did come to my house, but I don't know what he did before that.
And what time did you say he showed up at your house?
I don't know exactly. I didn't think it was going to be important at the time, so at the time I didn't notice.
Now, I think most people at this point in time, you've been arrested in Letcher County your entire life, haven't you?
Yeah.
And I assume you've seen this video also, haven't you?
What video?
The video in Judge Mullins' chambers.
Yeah, just once, part of it, yeah.
And you know who Kevin Mullins is.
Yeah, I know Kevin.
He's district judge.
I know Kevin.
He's a district judge, correct?
Yeah.
Was a district judge.
Yeah.
Better way to put it. And you saw.
I
the
saw,
shooting.
yes.
Go ahead, no?
Thank you, ma'am.
But just briefly,
Sure.
when Mickey came to your house, you knew that he'd been to the doctor that day.
Yeah.
Okay. And knew that there'd been some concerns about his mental health.
Yes.
And that was the reason he was taken to the doctor.
Yeah.
And when he was at your house, he kept the cameras on at his house all night long.
Watching his house.
Did he ever turn them off?
No,
Did they keep you up at night?
I could hear the little crickets and jar flies all night.
And was he concerned the entire time about what was going on with
Yes,
his
he
life? and
was.
health?
Yes, he
All
was.
that.
No, you weren't there.
All right. Thank you, ma'am. You may have a seat. Any other witnesses?
Judge, I have a pretrial officer that interviewed Mr. Stines prepared to testify, but if the court can take judicial notice of its own report, then that won't be necessary. You can release that witness.
Sure. that'd be
No,
fine.
no objection to the report, Judge.
That's all the witness.
Uh, Anything from the Commonwealth?
Nothing, Your Honor.
All right. Ms. Bartley, any argument?
Your Honor, I will ask the court, understand the court's ruling in order, I believe in December, regarding the report from Dr. Allen.
Yeah,
I will-
and I will take that under consideration.
Yes, Your Honor.
Not in this.
Yes, Your Honor, thank you. That's absolutely an issue that we want to make sure we preserve. Judge, in terms of argument, it's the Commonwealth's burden to establish that the proof of Mr. Stines' guilt of a capital offense is evident or the presumption of his guilt of a capital offense is great. Now, the cases say, and again, Markham v. Broughton sets the standard that says where conflicting evidence creates a plausible basis for self-protection or the reduction of the offense to a non-capital degree, the Commonwealth has failed to meet its burden and he's entitled to bail. Judge, the Commonwealth here, the only proof they've put forth is a video. And while I agree it's a compelling video, it absolutely is compelling evidence. I understand that. But the only thing that the video shows is an act and an identity. We don't have any element of intent.
Yeah, I think he's
And
going to get
the
bond,
murder
guys.
Statute, Your Honor, anticipates, it actually makes an element, EED. EED is an element, or the absence of EED is an element, right? So they have failed, Your Honor, to put forth any proof as to the mental state, any premeditation, anything to that effect that would be necessary to take that and make it an aggravated capital offense. And our evidence, Judge, while it's been brief, we have Ms. Stines, we have the court taking judicial notice of certain pieces of evidence of the pretrial report. I believe that that creates enough of a presumption, Judge, or enough of a plausible basis, which is the standard under the law, to show that Mr. Stines acted in such a way that a jury could believe that he was either operating under extreme emotional disturbance or potentially even insanity. And I understand the court's ruling again on the insanity argument, right? That, you know, that's an affirmative defense. That's for trial. We're not having a mini trial here today on whether he is insane, whether he had the requisite mental state. But all of that proof, or the absence thereof, goes to whether or not he's bailable. And that's the only thing that we're looking at today. Did their proof meet that burden? Now, I think evidence put forth by our single witness, Judge, and then of course what the court is going to take notice of, demonstrates that there is a plausible basis that this comes out of the capital murder arena. I think evidence that he was, Ms. Stines testified that he was acting out of his character, that he was paranoid, that he was having concerns about the safety of his wife and daughter. And the standard for EED, as the court knows, it's not an objective standard. It's not a reasonableness standard, what a reasonable person would think. It's what he thought. What did Mickey Stines think was happening at that time? Why was he in fear? Why did he believe that his wife and daughter were in danger? And he clearly did. Now, the Commonwealth makes much of the fact that he left his house and he was at his aunt's house, but I don't think all that matters when you look at his mental state that he had at the time. He was completely out of his typical character. And, the court will take a look at that video. And again, it's compelling, but I think there's so much more, Judge. And although the court, again, said that insanity is not necessarily relevant at this stage, the cases that we look at, there are several cases that say that bail should have been granted in a capitally charged case. And I think it is relevant that the Commonwealth hasn't filed a notice at this point, right? So RCR, I believe, 402 says that.
Well, as we discussed earlier, that's being held in advance at this point because there's outstanding issues in regards to that.
Sure, Your Honor. What I'm saying, Judge, is that.
Let me ask you this, Ms. Barr, because I do want to kind of move things along.
Yeah, absolutely.
What is the bond you're proposing?
Judge, what we requested previously was 50,000 cash for property.
That's not very
Judge,
much.
With any conditions that the court deems appropriate. The court has heard all of the proof on, you have a place to stay. He's not a flight risk. He has no criminal record. He, in terms of the pretrial risk assessment, he's a low 0, the lowest that he can be. There's no reason to think that he wouldn't be compliant. He wouldn't reappear. There's no reason to think that he would reappear, Judge. So we would ask for that, but with conditions. I think there are sufficient conditions to ensure his appearance, sufficient conditions to keep him and the community safe. An ankle monitor would be appropriate, Judge. No movement, GPS monitoring if necessary.
An ankle
no
monitor, huh?
firearms, clearly. Yeah, I think the court can fashion any number of remedies to allow him to be out in the community and prepare his defense outside of the confines of Leslie County Jail. And so we would ask for that same bond, Your Honor, but of course, whatever the court deems appropriate, I'm just asking the court to find that he is in fact available and to set a reasonable bond.
All right, Mr. Steele.
Yes, Your Honor, I'm going to point everything she mentioned regarding insanity. Those are all defenses, every one of them. We're not here for that at this point in time, but in regards to the bond, I'm going to point the court direction of Commonwealth v. Jones. I believe I gave the court the last time. It's 2024 Westlaw 2982769. And in that case, out of Breckenridge County, the Commonwealth chose not to seek that. And at that point in time, the circuit judge says that I'm going to grant a bond. There's a long analysis of that in regards to criminal rule 4.02. 4.021 says everybody is entitled to bond except those charged with a capital offense. And the conclusion, I'll read the conclusion in the last chapter. Jones was charged with a capital offense, which death was a possible penalty. Per Kentucky Constitution, Section 16, we believe it is incumbent upon the circuit court to make an express finding as to whether the proof of Jones' guilt is evident or the presumption is great. One or the other. Accordingly, we reverse the orders of Breckenridge Circuit Court granting bond and setting conditions and of release and remain the matter for determination of whether the proof of Jones' guilt is evident and the presumption is great. If the court answers the question in the affirmative, then Jones is not available. The evidence is that Judge Mullins was a public official, which is would make this a capital offense. So we do not believe he is a available defendant based upon the charges.
Your Honor, if I may just respond to that briefly. Jones, Your Honor, as the court knows and cited in its order that was dismissed as moot. I don't think the court ever reached the ultimate question, so it's still an unsettled matter of law, but the analysis is the same,
Sure.
Judge. So I don't think that case is really relevant at all to the court's analysis.
All right, I will get an order out on bond. I am going to be real honest, the thought of the $50,000 cash or property bond is something the court would not entertain.
Good.
The court does
That's too low.
believe that he is available. This would be a bond that would be much more significant than that, but I'm going to hold that in advance and get an order out to you all in regards to that.
Yes, Your Honor.
Next, we've got a petition for change of venue.
Yes, Your Honor. If that is a Commonwealth's motion, we have attached 3 affidavits to that also. We've laid out the law for the case. I'm not going to go further. There was an attachment also, I believe, to the original motion showing also the news coverage, not just locally, but also nationally. I did just a little searching yesterday and updated some numbers. It appears the Mountain Eagle, which is the local newspaper for Letcher County, has had, at this point in time, had 103 articles written on this. They have a Facebook page, over 30,000 members on their Facebook page. I believe of the 103, I believe the number I got was 20 of those were speak your peace articles, in which people can just make and say what they want to anonymously. And then there's comment, as you can imagine, in every direction. This was the stock story in 2024 on both the Mountain Eagle website and on the Mountain Eagle Facebook page. WYT News, a local, I'm going to say southeastern Kentucky, has had 33 articles, news coverage in the last 12 months, I believe it is what I showed. And I'm not going to say what people say because obviously I'm being quoted.
Sure.
But suffice it to say, a large number of the community has strong feelings one way or the other. And it's just not in Letcher County. I was had a conversation with victim's family in Perry County just 2 weeks ago. And of course, it came up, and he was very strong on his opinions as to what it was. Not just based on news stories, but based on just rumors and word of mouth and some outlets that, I didn't get into the YouTube bloggers, which has been insanity, to say the least, in regards to theories and things they are saying out there. I believe defense counsels even commented on some issues as not being true, that have come out in those. It's our position, Judge, that the news media coverage in Southeastern Kentucky and even Central Kentucky, because the IMT they're a sister station to the Lexington channel. The coverage has just been unbelievable. I could go into Facebook pages all over Southeastern Kentucky and find strong opinions. The market changes when you get in Western Kentucky in regards to where their news has got where they receive their news. You really receive news out of the national network and not the Lexington or South Kentucky network. So that's our position, Judge. The affidavits are of a practicing attorney, of the county attorney, and the county attorney. The county clerk and the circuit clerk weren't available the days I was over there. I think they realized what was on the docket and they both got out of town. So those are the people that I could catch up with. I can tell you I could get these signed by almost anybody in Letcher County. And these individuals that ran for office have a finger on the pulse.
Agreed. But Judge, I talked to somebody and he had an opinion.
We had subpoenaed the people that had signed the affidavits for the change of venue. And I think one of them is Miss Ashley, Ashley Thieves.
Okay.
If I could call her.
Sure.
Is Ashley Thieves okay?
Yes,
Thank you.
Ashley, somebody.
Ma'am, if you would raise your right hand and sworn, do you swear from the testimony you give me the truth, whole truth, nothing but the truth?
Yes, I do.
Please state and spell your name.
Ashley Sturgell, ASHLEY STURGELL.
Thank you.
Well, I'm sorry, Mr. I thought it was Fields. I don't know where I got that from.
I'm married, but I did not change my name.
Good. And you state your name for the record. Where do you live?
I live in Whitesburg in Letcher County.
And is that like, do you live in a community or do you live in town there?
In the community, in town.
What is your community's name?
I live in Whitesburg in the upper bottom there.
Okay. And have you lived there all your life?
No,
How long have you lived there?
I've lived there for approximately 3 years.
3 years.
Yeah.
Now, let me ask you, what do you work anywhere around the courthouse or anything like that?
I'm an attorney in town,
Okay. And what kind of law do you practice?
general practice.
Okay. And did you happen to be in the courthouse the day of this occurrence?
I did, yes.
And so you could technically be kind of a witness.
Yes,
Would
that's
that be
correct.
right?
Yes.
And
Sort of.
did you have any emotional feelings about this?
I was there that day, so I think,
Did it shake you up?
of course.
Okay.
Yes.
And so when would you have moved to Whitesburg there?
I think I moved in the fall of 2022.
Okay. So you lived there approximately 2 years, would that be right, at the time of this occurrence?
Yes.
Okay, in that same place?
Different places in town. I've lived several places.
Oh, okay. Let me ask you, you state in your affidavit there that in support of this motion to change the venue, let me ask you, what public opinion? How many people are in a public opinion?
I think it refers to the state of public opinion.
Well, that's what I'm asking. Let me show you what you're saying.
I've got a copy of it,
Okay.
sir.
Well, I just wanted to know how much.
Stop messing with the sound. Court TV, Law and Crime, whoever is running it. Fire the sound guy. Somebody stepped on a cable or something. I don't know what is going on. I'll check and see if okay, we're gonna switch back over to Court TV because they have sound.
Do you practice any criminal?
I think,
Did
A
shake
little
you up?
bit.
of course.
Okay.
Okay. But we're-
And so when would you have moved to Whitesburg there?
I think I'm,
Approximately.
yes.
Okay, in that same place. You stayed in your, change the venue or in a public opinion.
I think it refers to the state of public opinion.
Well, that's what I'm asking. Let me show you what you're saying.
I've got a copy of it,
Okay.
so.
Well, I just wanted to know how much.
oh boy, guess they lost it too. So that was pointless.
Eight years now.
Oh, okay.
Yeah.
All right. And tell me something. Do you practice any criminal defense, anything like that?
Yes.
So you understand when you said that the Commonwealth couldn't get a fair trial. Is that right? That you said even they couldn't?
I think I said both.
Both
neither
parties,
party
well,
could get a
neither
fair
party
trial.
could get a fair trial. I'm just going to talk about the Commonwealth.
Yeah.
You understand that as a criminal defense, somebody that does that, that you start off with a presumption of innocence in every criminal case.
Yes.
Presumption of innocence. So already the Commonwealth has got a burden to go over to overcome that presumption of innocence. Isn't that right?
That's correct.
Okay. And what is a fair, what to you is a fair trial for him, Mickey Stines?
Again, I don't believe either party could get a fair trial in a community where that you have a victim and a defendant who were both elected public officials in
Well,
that community, which inherently brings with it a lot of love and a lot of hate and strong opinions toward either.
Okay, but I'm just saying that in a trial, could you understand why a person would want to be tried in their home county?
I can see why people would want to, but I
Okay.
can't see why anyone would want to in this situation.
And in this public opinion that you talk about, have people expressed to you that no matter what we hear in that case, in that trial, we're never going to believe anything the Commonwealth has to say?
Excuse me, can you repeat that?
Has any of those people that you said have public opinion,
Mhm.
has any of them expressed to you that no matter what is said in the trial, I'm not going to believe anything the Commonwealth puts forward?
There are people who have taken strong stances on either side,
But
very publicly. Now, do I think that someone would come in and admit some sort of inherent bias? No, I don't think that people even realize that they have that usually. I don't think someone would walk in here in front of all these people and admit to being racist, for example.
race isn't an issue in this case.
I know, but I'm just
Okay.
saying, those types of inherent biases, I don't think people would be willing to just freely admit to that.
True, but that's in any case you try, no matter what the case is.
Correct, where there's some sort of bias.
There might be a bias about anything.
She's up for judge.
And all the court can do is ask, all we can do is ask questions and go by the answers that the people give, right?
She's up for the
And
district
you're-
court
you're
position.
saying that the Letcher County people would give false information under oath about.
Oh,
on board,
boy.
are you?
No,
Okay,
what I've just said is that, and I'll repeat that, I think that most of the time when people take strong stances, they don't even realize the bias that they actually have.
I understand, but no matter what, he's presumed innocent.
Correct,
He starts off right there.
correct.
So there's a bias there. Isn't that kind of a bias that if he has to start off being presumed
It is
innocent?
kind of a bias.
Presumption of innocence, yes, ma'am.
I don't know that I would consider that a bias.
Okay. And let me ask you, did anybody ever express that no matter what the Commonwealth put forward, we don't believe it and we're not going to pay any attention to it?
I think people have expressed that in other words. Yes, people have continued to, even locally, to have opinions and very publicly.
Oh, how dare they?
And support certain rumors, which I think Mr. Steele hit on, that even the defendant's own counsel have now said on numerous occasions are not true. So, yes, that's
Now-
the answer to that.
Okay, let me ask you something. I'm just curious again, I'm just wondering, how many people have you, expressed this opinion, or how many people are you saying are in a public opinion?
Sir, too many that I could count over the last year and a
What's the
half.
population of
Oops.
Several thousand.
Letcher County?
I think, I want to say, I don't know. I don't know the answer to that. Small community,
And now you're just in private practice right now.
yes.
Were you ever the county attorney or in the county attorney's office?
No,
Okay, that is. Did you know any of these other folks here, Matt Butler? Did you know him? by any chance?
yes, I know.
And do you know Mr. Holland, or is that his name? Haller, I'm sorry.
Mr. Hatton,
Yeah, Hatton.
yes,
That's it, yeah.
yes, I'm familiar with both of them.
Okay, and that's people you've talked to about this too?
I talk to them regularly.
Okay.
Basic question. You could just ask that question.
Through work. We work together.
And who asked you to fill out an affidavit?
The affidavit that I signed was presented to me by Mr. Steele.
Thank you, that's all.
Sir, I've got a few questions. My role's a little different than Mr. Cox, and he's worried about his client. I'm worried about justice on both sides.
Oh,
And he's-
oh.
Just concentrated on the Commonwealth not getting a fair trial. Does he say Mickey Stein has a presumption of innocence, right?
Yes,
Is it your position that if he was to be tried in Letcher County, that Mickey Stines would not have that presumption when he walked in a courtroom in front of a jury here?
I don't.
Objection, Judge. Objection. Can we approach the bench here? Sure. Which room?
Gonna have a little bench conference. Oh, guys, that takes me back because that reminds me of a case I had. I mean, there were many issues with the prosecution in that case, but one of them had to do with the derogatory comments he made in his closing argument about the respective roles of the state and the defense. And he's arguing, oh, we're the truth people. They're just over there trying to get the guy off. They don't really care about the truth. I should see if I can dig that up while we're while we're waiting. Yeah, so I found I'll share this maybe when we get a break, but I found this article. I can't find a date for it, but it says that she was March 6th of 20. Oh, okay, so this is old.
Is it your opinion after talking to people, and we're gonna get into this a little bit, that Mr. Steins would not
She
have
was
the
up for the
findings of
district county
evidence
seat.
when he walked in on that first day of trial? Presumption of innocence, I'm sorry, presumption of innocence.
I think that it would be hard to there.
And is that, you kind of talked about this, is that because of the mindset of people either for or against him?
Yes,
And you do criminal defense, correct?
yes.
How many times have you had criminal cases that have had over 103 articles written on it in the Letcher County paper?
I have not had one yet.
You've had voir dire, talked
Yes,
about voir dire. That's one of the issues you go over, isn't it?
yes,
Is media coverage.
yes,
You said you're in general practice.
yes.
How many, of course, most people don't understand, but just walking in and out of courthouse, people talk to you on a regular occasion, just pull you out, hey, I need to ask you a question.
Of course,
So
yes.
how many people, I'm not asking you to guess, but just give us an, how many people do you think you talk to on average in a week in Letcher County?
Oh. I couldn't say. I would say
I couldn't either.
Yeah, I
That's
don't,
kind of
it's a
back question.
lot.
Sure.
Too many for me to remember on
How
a
many,
daily
how long have you
basis.
lived in Letcher County?
I've actually lived there since the fall of 2022, but I've worked there in practice since 2019 in the summer.
So you are familiar with the community.
Yes,
You also, you know quite a few people in the community now.
yes,
Is that just in Wattsburg, or is that in different areas of the community you know people?
all over the county in different areas.
And I'm just curious, how many times does the conversation turn to this case? And just a general, everybody getting together, sitting around talking, how often does this case come up?
Very often, unfortunately.
When you're talking to people, and I'm more, not talking about the people in the courthouse, the people out in the community that you say you know, is it your position that they have strong feelings as to innocence or guilt, one way or the other?
Yes,
Is it fair to say that there are rumors going around in the community?
yes,
That people do believe, regardless of what's been said, that the Commonwealth would not get a fair trial. That people have said, and I've read it, I'm sure you have, and I hate to quote people on the internet, but people in the community that said he should be free.
yes.
What he did, he should be free. I think I've read one, he should be given a key to the city or something like that. Have you heard those type of comments?
I've seen them and heard them. Yes,
And those are from people in Letcher County,
yes, those,
all of the age of being on a jury panel.
yes, they appear to be adults on Facebook and various social media platforms. Yeah.
Now, when I see something on Facebook, I may not know who they are. I'm assuming when you see names on Facebook, like if I did in Laurel County or Knox County, I know some of those people. When you talk about these people that are saying things, are you talking about the unknowns, the anonymouses, or the people that like, oh, I know them, that represent their kid, or I did a will, I did. Are you talking about just the people you know that live and reside in Letcher County?
Yes, I've seen it from people that I know and or know of, and I've seen it from random people that I don't know. But I've definitely seen a lot of commentary that does appear to be people who are local, either taking one strong side or the
Oh,
other.
yeah. And if this is very, would you say this has been very divisive in Letcher County?
Yes, absolutely.
That's all I have.
Any comments?
Could I ask you just a very few questions? Sure. That's all right. Ma'am, how long have you practiced criminal defense?
Since 2019,
And was it just in Letcher County or is it in other counties?
other counties as well.
Okay. You weren't by any chance a public defender, were you?
No.
Oh, okay. Because they practice in other counties too, but I just let me ask you, how many changes of venue have you ever asked for?
I don't know.
Have you ever?
I don't know if I may have at one point, but I
You
don't
would
know.
remember.
Okay. Usually you ask for a change of venue because there's kind of a.
Are you talking just in a criminal case?
Yeah, criminal case, yeah.
I don't think I've asked for one in any of my criminal cases, but I have asked for it in other cases.
Okay. But like civil cases or something like that?
Yes.
And in your experience as a criminal,
Like some
Just
family
one
case
thing.
where the guy moves.
how many times does the Commonwealth ask to move one of your cases to another county?
None, not yet in my career, but I don't believe that's uncommon in high profile cases.
Well, I understand that, but I mean, you've never had a case that the Commonwealth's ever asked for a change of venue.
No.
And let me ask you this, would you know if case has been, I mean, where would it go if it was changed? Where in the world would it go? Because it sounds like it's just almost worldwide.
I am not the one in charge of that, so
I-
I don't know.
Yeah, I got you, but you can, but what I understood you to say is that just massive amounts of publicity and talk, social media and all that other.
I don't think anyone in this room could deny that.
That's all.
But she's kind of made herself an expert.
Ma'am, has there been anybody you've talked to in regards to this case that you don't believe has already formed or expressed an opinion on the guilt or innocence on this case?
Judge, I believe people have already formed their opinions.
On this case?
Yes.
You're in the courthouse every day, or not every day, but at least every week in Letcher County.
Yes.
In your opinion, in your conversations with the citizens in Letcher County, is there anybody you've talked to yet that hasn't expressed or formed an opinion on this case?
There have been people who, of course, they want to ask questions,
Sure.
but, no, I think that for the most part, I feel that for the majority, people have formed an opinion already.
Thank you.
Thank you. Thank you, Your Honor.
Any other witnesses?
Mr. Jamie Hatton.
Jamie Hatton? Sure.
Yes, sir.
Is this a guy named Jimmy or sound like Jenny?
All right, Mr. Hatton, if you would, please raise your right hand and be sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can change now. Please state and spell your name for the record.
Jamie Hatton, Jamie Hatton.
All right, thank you. You may ask
Thank you,
counsel.
sir.
Jamie.
Mr. Hatton, where do you live?
Watford.
And do you hold any position, elected position or anything like that?
Yes, I'm the Letcher County Attorney.
Oh, okay. Who asked you to sign a petition for a change?
Mr. Steele.
Okay. And as the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay.
Didn't come up.
I didn't see it at the preliminary hearing.
So is he a party?
All right.
I was
And-
Mr. Stein's attorney at the time of the commission of the offense, so
You were.
I wouldn't.
Oh,
I understand. And
but he didn't
let
recuse?
me ask you, when you say community, how many people is there in Whitesburg?
About 7,000 people in the city limits, 20-some thousand in the county.
Okay. Now, you certainly hadn't talked to everyone of them.
Nope.
Okay. How many do you guess you talked to about this guy?
To guess, hundreds, I would imagine.
Okay. And I know that, has anybody just said that I am going to not believe anything the Commonwealth says about this case?
No one said that. I
No
mean,
one said.
not to me.
Anybody said, no matter what's said, no matter what's done, I'm going to find Mickey Stines not guilty?
No one said that to me.
And you agree he has a presumption of innocence?
Sure.
Okay. So you're a prosecutor, right?
Yes, I've sat at this table and at that table as well.
Okay,
throughout my
okay, I
career.
got you.
Sure.
And what is a fair trial for the Commonwealth? What does that mean? If he has a presumption of innocence, you already start with something right off the bat.
I think fair is subject to the eye of the beholder. You know, what's fair mean to you?
Well, that's a good question. But I was just going to ask you this. Would it be important, do you
How
think?
Clinton-esque.
and Mr.
What's
Stines
fair?
hadn't asked for a change of venue. Do you think it's just about equally as important that he be allowed to stay in his own county and place his trust in the people of Letcher County to judge his case?
Sure.
You think they can?
Think who can?
You think the people of Letcher County can judge his case fairly?
I mean, I've got a great respect for the people of Letcher County, but I couldn't imagine, you would almost have to have 20,000 jurors in there to try to find 14. You know what I mean? They don't have really strong opinion.
I understand what you mean. But I mean, do you understand, should a person be able to be, those people put their trust in Mr. Stines when they elected him. Mr. Stines put his trust in them. Do you understand it would be important to him to be tried in his own county?
Yes.
And they would be fair.
I don't know if they could be or not, honestly.
Okay. Would they be honest and say, no, I can't be fair?
How can you say? You've done a lot of voir dires.
Yeah.
I mean, we're honest with you.
I understand.
Yeah.
That's a chance we have to take.
Sure.
Judge, that's all I have.
Just a few questions, John. Debbie, how long have you been county attorney?
15 and a half years now. We're halfway through this year. Yeah.
So you've obviously politicked a lot in Letcher County, know a lot of people in the community.
Yes, sir.
How long have you resided in Letcher County?
Other than the 8 years I was off to school, all of them.
Or even when you was at school, your mom and dad live there,
Absolutely.
families from Letcher County,
Yes,
have roots going back to Letcher County, all over Letcher County, don't you?
yes, indeed.
And again, is there people in your community that you, and how many, as a county attorney, I don't even want to fathom, how many people you talk to in a week?
I would say, you mean just in my work?
Just
or
in general,
going to-
yeah, not counting family, but just people walk on the street, people calling the office, people wanting to visit your office.
Probably 100 or more weekly, sure.
And you have a private practice also, don't you?
Yes,
And so you deal with car wrecks and other litigation, other than just criminal prosecution. So you have
Sure.
clients, not just from the criminal world, not just officers coming in, but you have other clients coming in for wills and estates and all that, those probates.
yes, that's true.
How often does conversation turn to this case?
Well, for the first probably year after it happened, pretty much the first time I'd see someone, and talk to them, they want to talk about that.
Well, because you're the county attorney.
Sure, yeah. And then whenever I'm in court, anywhere else in the Commonwealth, that's the first thing. Oh, you're from Letcher County. They want to talk about this case. So,
So it comes up frequently.
yes.
Not as much today, I guess, as it did the first year, you said. In those conversations, just talking about the people of Letcher County, not with other counties, we're talking with other attorneys, because they're always inquisitive. When you're talking to just people in Letcher County at ball games or cookouts or fire department raffles, whatever, how
Wild.
often does this still come up?
Really, every time a hearing or something like this comes before the court, it pops right back up to the conversation of the day, and then it'll fade into the background and come back.
When that next article comes up, there goes it.
That's it.
Do you subscribe to the, and I hate to put you on the spot, do you subscribe to the local newspaper?
Yes, I do.
And have you seen articles on this?
Oh, yeah, lots of them.
Do you also check their website, read articles on the website?
I used to more. Now that I've got the subscription, I just read in the paper for the most part.
Can you tell us, if you're familiar with, what is the Speak Your Piece? What
It
that?
is a sort of it's really cool, but it's a local opinion thing. Anyone anywhere can call in and leave a message and they'll post it in the newspaper.
And then they're on the website.
You'll post it in the newspaper.
But publish it in the newspaper. It has a whole section. Yeah.
You can call in anonymously,
Yes,
leave a voicemail, and publish it in the newspaper.
correct.
And in regards to online, you can actually make comments to that. Can't you? Have you seen that? Are you aware of that?
No, I've never seen Speak Your Piece online.
Okay, fair enough. And I want to ask you more on that. Jamie, in regards to the hundreds of thousands of people you've talked to in the community in the 2 years, almost 2 years since it's come about, what do you think the percentages are of people that have made their mind up or have very strong opinions one way or the other?
I couldn't say a percentage, Mr. Steele. It just seems like there's a very strong Team Mickey and there's a very strong Team Judge Mullins, and lots of people tend to fall on one team or the other.
And I think you even said you'd have to have 20,000 people, get 14 that's going to fall in the middle.
Yeah.
Let me ask you, Jamie, in regards to you said Team Mickey and Team Judge Mullins, are they pretty rooted in their position?
Seem to be, they really do. They seem to be from the start, from the outset. People started teaming up, it felt like.
And as a county attorney and as a public defender, do you see change of venue as appropriate in this matter, based on your understanding of not only the people of Letcher County, but also of the rule of law?
Yes, that is my opinion. Just for judicial economy, for one thing, we can bring this circus back to town and try and do this, and just you'll just end up having to go to another venue eventually. However many times you want to set it for trial in Letcher County, it just doesn't seem feasible.
And you've been through the four-hour process, picking a jury multiple times in Letcher County, haven't you?
Yes, I have.
That's all I have, John.
You follow,
Just a few follow-up.
Sure.
Mr. Hatton, I heard that you had been I'm a county attorney for 15 years, been a public defender.
Yes, yes,
How many times have you filed for a change of venue?
never,
Never.
never.
So you didn't have any high-profile cases or any cases you ever worried about?
Nothing like this, nothing like this. No, I can-
And how many times have you ever seen that the Commonwealth filed for a change of venue?
It's the first time I've seen it.
And I think you said whenever you go out of the county especially, people ask you, and then when they find out you're from Letcher.
Yeah.
Is that because you're with the county attorney's office or just, I'm a citizen of Letcher County?
I don't know.
Don't know.
You'd have to ask them.
Okay, I got it. And can you see, no matter what, I know you said that this could be a terrible situation, but did you ever know of any cases that were real high profile that they tried them right there in that county that it happened? No matter how high profile.
I would imagine this is the highest profile case in the history of our little county.
Of your, yes,
Yeah.
yes, but I'm just saying high profile cases. Did you ever hear of that case in Pulaski County where the sheriff got assassinated?
Object,
Okay.
No.
move, wrong.
Never heard of that one.
That's all, that's all.
Nothing but
All right, thank you, sir. Your release from your.
Now,
Yes, sir.
thank you.
Judge, if you'll permit me, I'd like to call out the name of just one more person, make sure they're not here. And that would be Mr. Matthew Butler.
Is Matthew Butler in the courtroom?
Could we approach the bench on that matter?
This is just some wild court proceeding for me to watch. Like all of this is super bizarro court. Okay, this courtroom itself, first off, yes, so janky. I mean, look at these shitty tables. They don't even have a witness box. Okay, they have to stand up here at this. This is like a music stand. Okay, they literally pulled this like from the music room at the elementary school, and that's what the witnesses have to stand at, like it's some kind of endurance contest or something. Whatever microphone they have, like the, tiniest movement makes the whole thing explode. We've got the judge's horde back there in the corner. Like this courtroom is also, serving as the bunker for the apocalypse. Make sure you've got your essentials stashed back there in a big pile. The clerk's in a t-shirt. Like this is just crazy. The county attorney was also representing Mickey at the time, but is here in court, never recused himself, but like is testifying for the state, for the Commonwealth on behalf of the change of venue. I'm kind of shorting out with all of this stuff because it's really just kind of wild. And then Ashley, who's like, how on earth, like, why did you agree to insert yourself into this? Ashley, okay, so I was talking before, it looks like this was a little bit old, but it's from last year. She was up for the judicial vacancy in the district court. This has got to be Judge Mullins' seat, right, guys? Judge Mullins was killed in September of 2024. They're trying to fill the position in March of 2025. She was up for his seat after he died. This is freaking wild. I don't even know what to make of this. So I gotta assume she didn't get it because she's still doing her private law practice there in Whitesburg, which is also like, just there's an interpretation process for me. It should be a little bit better. I'm not great with the Southern accent, and I don't know. Kentucky has a flavor that's like, this is not Appalachian. This is not like pure Appalachia. It's got a lot of Southern to it. So I don't know. I'm having to like interpret all these things.
All right, ladies and gentlemen, we're gonna be in recess for a few minutes. And we will start the docket back here.
So they're going to go in recess for a few minutes. And they had the sidebar right after Matthew Butler wasn't present. Are we doing a material witness warrant for Matthew Butler or something like that? Are we trying to hunt him down? Seems like maybe we are, but not really clear. Anyway, so now I'm curious who did get who. Letcher County District Court Judge currently is Nick Whitaker, appointed in March 2025. So he's an attorney with Hatton and Watts Law Office. Is that by any chance? Is that by any chance Hatton, as in Jamie Hatton, the guy who was just up here testifying? What is with this case? And these like everybody is connected. I get it. I know small communities are a thing. I practiced in them myself. Not super, but like literally freaking everybody has a connection here. And none of this is like disturbing. None of this is disqualifying. Not even a recusal. I don't know, guys. I'm shorting. I really am. Like this is hard for me to process. Oh, wow. I don't know, just by way, like, to kind of elaborate on this interpretation problem that I'm having, when they talk about things like the upper bottom and the lower bottom, I'm assuming that they are talking about what I would call a holler. Is a bottom a holler in this part of Kentucky? A hollow. But like Butcher Holler is where the coal miner's daughter was from. So I'm having to like think all these things because I don't know what else the upper and lower bottom could be referring to. So my notes are a total mess on this one because I'm like, what is the upper bottom? I don't know, guys. Feel like I'm kind of holding on the reins of a runaway team or something like that. I just keep getting jerked around. This is sort of nuts. I can't believe they only asked for $50,000 bail. That is insane. And I have to say, like, yeah, I think he's going to get bail. I do. Well, we can talk more about that. But 50,000 is nuts. Like 50,000 is what you might get for like, you've been trafficking some cocaine, some large quantities or something like that. Maybe you're part of a burglary ring. Like these are your $50,000 bond. At least this is just my perspective. Obviously don't know Letcher County, but 50,000 is like, it's not petty, but it's still relatively lower level felony stuff. It's not crime of the century stuff, but maybe you've got a long sheet. You're one of the, you're just one of the repeat shitbirds. You're in and out all the time. They know you're going to fuck up if you get out. So they just set it, high-ish because they know you don't have $5,000 to give the bail bondsman. Not a murder bail. This is not a murder bail. So I was kind of glad to hear the judge just call that right out. Yeah, that won't be happening. That won't be happening. Oh, there's the mom and the daughter. Of course, Court TV has to show us them. How sweet was Sherri and her bubby. Sherri and her bubby like so humanized this case in a way that, I mean, that's potentially some powerful stuff when you got a jury in there, and if you got the aunt that you get to call and talk about her bubby and the hard time he was having, that's gotta think that's gonna resonate. The GPS, they're like, stick them on a GPS. Oh man. Oh man. Okay, so the GPS is like the genesis of all of this, guys, the ankle monitor, because that was the issue. That was the position in the sheriff's office. It wasn't in the sheriff's office, but it's so convoluted. It would just kind of end up inevitably being performed by a sheriff's deputy for the district court and the whichever the other court is, for their ankle monitors, and they run, they run the program. And so Mickey Stines did this originally when he was a deputy in the sheriff's office. That was part of his position. He was the ankle monitor guy. And then, he ends up getting the elected position, and one of his deputies takes over as the ankle monitor guy. And then the ankle monitor is how this guy was coercing, this is the whole salacious part of the case, where the deputy would use his authority with the ankle monitor to, make offers they couldn't refuse to women who were on the program, or sometimes I'm sure it was probably a mutually agreeable situation, but the whole favors for I'll cut off your monitor or whatever. And so that's what led to the civil suit by Sabrina Adkins filed against Letcher County, against Mickey Stines, the sheriff's office, etc. Arguing after the deputy was like convicted of a crime, convicted of a sex crime. And then she files this civil suit, and it's like, what is old is new again. We're back. And so then it just makes me wonder, so who exactly is running the home monitoring system right now? Who's running the ankle bracelets? Is it still just some random deputy in the sheriff's office? And how well does that deputy know Mickey? Like, this whole thing is so freaking incestuous. It's just insane. It's just insane. By the way, guys, the civil case, I don't know if you saw, the civil case settled. It was set to go to trial a while ago now, at least a couple months, I think, but settled on the eve of trial. So we did not get to have a trial in that matter, which is a little bit unfortunate, I think, because of how it
Can you hear me
played
okay?
light.
All right, counsel, you can approach the question.
They're going back up.
All right, sir, if you will, please state your name for the record.
Matt Butler.
All right,
Oh,
Mr.
they went
Butler,
and found him.
Your first going to be a question on counsel on behalf of Mr. Stines. Go ahead.
Mr. Butler, would you state your full name
Matt Butler.
and what position do you hold in Letcher
On
County?
the column.
I'm sorry,
Go ahead with the question.
I'm just gonna ask, what position do you hold in Letcher County?
I'm the Commonwealth Attorney.
And how long have you been Commonwealth Attorney?
July 1st of 2024.
Mr. Butler, I guess I gotta ask you, we tried pretty hard.
We don't need to discuss
All
the
right.
subpoena issue. Ask a question.
Okay. Let me
I
ask
didn't
you,
show up.
you signed an affidavit, who asked you to sign an affidavit for a change of venue?
I believe that was the Commonwealth.
Okay, and how many changes of venue as you as a prosecutor have you asked for?
None.
So you don't have, as you sit here today, you don't have any issue with the, I guess, fairness or the ability to trust the Letcher County juries, do you?
I don't understand the question.
Well, do you have, as you sit here today, do you have any trouble in relying on the truthfulness and the fairness of the Letcher County jurors?
The question of whether or not Mr. Stines can receive a fair trial and whether the Commonwealth can have a fair trial is based specifically on that case. It is a case-by-case approach. If there were a case where a defendant could not have a fair trial and the defense wanted to move it, I would not object to that. If the Commonwealth could not receive a fair trial in a case, I would move to change venue on behalf of the
I
Commonwealth.
sincerely doubt you would not
But it's a
object.
case-by-case approach. This case is unlike any other that has happened, to my knowledge, ever in Letcher Circuit Court, but certainly in the time that I've been the Commonwealth attorney.
All right. Can you tell me what exactly is a fair trial for the Commonwealth?
A fair trial for the Commonwealth would be one where the Commonwealth feels like they have just as much of a shot of getting an unbiased jury as the defense does.
Okay. And if the jurors could said that they could follow the judge's instructions and follow the law, would there be any problem with that jury?
You're asking about whether or not that could happen at the time you're taking a jury in Letcher County. And my affidavit supports my opinion that you couldn't even get to that place, that there is no way to seat a jury in Letcher County, Kentucky on this matter.
Is that based on your personal talking with people or just on like the coverage?
I live in Letcher County and I've seen the concerted efforts like you, your investigator, and others to paint the jury pool, and I feel that it's extremely unfair, that you have taken great steps to imply that there's some sort of conspiracy that there's not, and the Letcher County jury could not see this matter. Also, the victim, the murder victim, was an elected official, and the sheriff was an elected official.
Okay. Now, let me ask you something. You didn't, Mr. Steele is the prosecutor in this case. Did you just voluntarily withdraw to get off this case?
Within about an hour of finding out that your client had killed our district judge, I had spoken with the Attorney General's office, and they had reached the same obvious conclusion that I was, that it would be better for a prosecutor from outside of Letcher County to sit in this matter.
All right.
Sure. 1 second, please, sir.
Not a very friendly witness, is he?
Mr. Butler, I'm back. Were you ever related to Mr. Mullins?
At one point in time, from December of 2014 until July of 2029, he and I were married to a pair of sisters. During that period of time, I did not practice in Letcher County.
Okay. All right. Thank you.
Mr. Steele.
No questions, Your Honor.
All right, Mr. Butler, thank you for your cooperation.
Thank you, Judge Cohron.
All right, any other witnesses?
No, Your Honor.
All right. Anything else on behalf of the Commonwealth?
Nothing further from my office this year.
All right. Any argument, counsel?
Judge, if I could read from the case, the mere fact that jurors may have heard, talked, or read about a case is not sufficient to sustain a motion for change of venue, absent of showing that the accounts of descriptions of the investigation of judicial procedure have prejudiced the defendant. That comes from the case Commonwealth versus Ronnie Lee Bowling out of the Laurel Circuit Court. It's cited at 942 Southwest 2nd, 293. And the reason I'm citing that case, Judge, I was the attorney in that case. Very serious case. And at that time, that was back, of course, this decision wasn't done until 1997, and the actual offense itself didn't occur until it was much earlier, sort of earlier. And London was a small town, pretty small town by then. It's grown some now. And I remember there was a lot of coverage. There was all kinds of talk, everything else. It was 2 robberies, 2 murders. And I moved for a change of venue for the defendant. And it wasn't granted. And believe me, there was a lot of talk, and yet we tried to get a jury, and they did, they got a jury in that case over my objection, but they did. They did grant the change of venue. And I would just ask the court maybe to look at that case, because when I asked for a change of venue, I was pretty much told that those things didn't matter much about reading about them, hearing about them, talking about them. And I think that's kind of the position they're in Letcher County. Now, I don't know why people are so concerned that maybe the Letcher County people couldn't be honest and fair, because they elected Mr. Stein. He put his trust in them, and they put their trust in him. And I think there's some position here where he should have the right to be tried in his own home county, where he feels comfortable and safe, and that he is around the people he knows. And again, I think from hearing from them, if it's that kind of a wide coverage, that was some kind of, there's so much to talk about. Where could you go? And where would you feel more comfortable? I know for his witnesses, at least they would be more convenient to be closer to home there. It would be easier for them to come to court. Now, as far as these cases being high profile, I live in Pulaski County. Several years ago, we had a sheriff that was assassinated. The trial of that person occurred right there in Pulaski County. And that was high coverage because he was assassinated. I just don't think that at this point in time, until we try to get a jury, and I think that's been the result of most of the cases that I've seen, that unless you try, you have to try. And then if you can't, then it's probably more pertinent to do it at that time. But at this juncture, I don't think that's been enough. Just having 3 people that are they're related to either by blood or they were at one time. Mr. Butler was talking about that. But to have people that are, working in the courthouse, one of them was a witness, and Mr. Hatton, I think, he's the county attorney. I think that's kind of telling. And I also think that the people that testified at least have never had a situation where the Commonwealth asked for a change of venue. Now, I know this case may be unusual, but unusual isn't the test. And I would just ask the court to consider all of that and not change that at this time until we've at least tried to get a jury.
All right. Response, Mr. Stines.
Yes, Your Honor. Let me just say, Mr. Cox, I remember those cases. When I say this, I'm not poking, but Mr. Bone was in 1989, killing a gas station. Mr. Catron was in the early 90s. I think mid-90s was when Mr. Catron. Just me and Mr. Cox spoke of, that was before the famous internet and the coverage of which we see today from bloggers and vloggers and YouTube, whatever. It is a much different reality of what we're dealing with today. I'd like to point out one of the things that's always struck me since we first got this case is that one of the admonishments that the judge gives a juror during the qualification is do not go by the scene of the crime and do your own investigation. This would require us to have a trial in the building of the crime. The video footage that we would show from the outside of the response, Mr. Stines leading, is of the building where they're going to walk in and out of every single day during this trial. So it's impractical, one, that they could not do that and not go by and look at the scene of the crime. The fact that these are both elected officials also cuts against their argument that it shouldn't be moved, Judge. Mr. Hatton, who's ran for county attorney many times, almost 16 years in, he said it's very team Stines or team Judge. It's just drawn a line in the community that we do not have a reasonable chance of getting a jury pool out of Letcher County. I believe when the numbers come back in Letcher County, their population is going to be less than 20,000 people because of the flood they had there a few years ago. I believe the number was, and Mr. Hatton said, in the mid-20s, but I believe the number is going to come back less than 20,000 in the next census. So, and they're losing population every day. I think he stated very clearly we get full 20,000 people just to possibly get 14% on the jury pool. This is from the county attorney who deals in these, and I can't imagine the phone call the county attorney gets. The reason I don't want that job is the amount of phone calls they're going to have to get in a day just from citizens on a daily basis. The case of Brewster, 568 Southwest Second, 235. And Interpret Shepherd is requiring a change of venue when there's been prejudicial news coverage. It's undeniable. I think parties talked about the inaccuracy of some of these news reportings that are detrimental. These, obviously, the news occurred prior to trial, which that's why we're here today and not at trial. And the effect of such news coverage is reasonably likely to prevent a fair trial. And I believe every witness that we had affidavits signed said he couldn't get anybody that would sit and actually give a fair trial on this matter. So Commonwealth thinks that the elements for the change of venue has been met, and we would request such.
All right. In response,
The only thing is that I'd say as far as prejudicial news coverage or any kind of coverage is based on like that video that you talked about. And that's not the end of the story though. And I think unless I believe that with the trend has been right, what I've seen in change of venue, you have to try. If in Pulaski County.
I don't think there's any case law that requires.
No, it doesn't, but I can say this because of the trend of what they're saying, how much coverage it gets and it's talking and talk and things like that. They sure got one in Pulaski, and that was an assassination of a sheriff.
And what year was that?
That was probably, and he may be right, midnights, I can't remember exactly.
I think it was 94.
Well, I think about that was pre-internet.
94.
But the internet itself is such a big unknown, how many people are on it, where they're at, and this, that, and the other. I mean, we could just go on and on, but where else in the world are we gonna go? So that's not what you do.
Well, that'll be, if I do grant the petition, that'll be the court's decision. First of all, there's been a line of questioning. I don't think anybody's trying to question the honesty or fairness of the people of Letcher County.
Oh, shut up. Don't have to kiss their ass.
This is a unique situation, to say the least. I am, at the request of defense counsel, going to review the case law that they brought up today and cited. But I can tell you the court is going to be hard pressed not to grant this petition for change of venue. I cannot fathom the thought of reasonably being able to obtain a jury in Letcher County with the amount of coverage. I do believe the county attorney said, and I'd already kind of thought of that analogy, it seems very clear that you've got a very divisive situation where you have Team Stines and Team Mullins, and these are some irretractable positions that would make picking a jury in Letcher County all but impossible. But I'm going to withhold ruling. I'll issue a written ruling after reviewing the case law cited by the defense as well as the Commonwealth and get that ruling issued. Anything else we need to address today?
Yes, Your Honor.
Okay.
Your Honor, as to the second phase of that equation, Your Honor, of course, we would maintain our objection to your motion. But in the event the court grants the motion, Your Honor, then I believe the parties should have an opportunity to address, I think the statute talks about the preference being adjoining counties first within the circuit. And then, Your Honor, so I understand it's the court's decision, obviously, but I do believe that the statute would require that we do have input as to the locale and be able to present evidence to the proposed location.
Well, and if I do grant the petition for change of venue, we can, I'll allow filings and requests and anything you'll wish to be heard on a potential location.
Yes, Your Honor, I just would.
I don't think, but like I said, it's not going to head to an adjacent county. I mean, realistically, if the court does grant the petition, I think we're going to need to be far away enough where the direct media coverage is not as focused as it's been in this part of the state. So,
As to that second equation, I mean, I understand, Your Honor, but I believe the analysis is a county to which there is no objection, Your Honor, on the second part of the analysis.
Right, but it also requires it to be in the most convenient county in which a fair trial can be had. My review, I've participated in change of venue cases, and in my review of the law that's been promulgated by the Supreme Court, there is wide discretion vested within the circuit court on picking that final destination. So
Yes, Your Honor.
we'll address that at the appropriate time. All right, anything else today?
Looking for the call, Your Honor.
Mr. Bartley, anything else on behalf of Mr. Stines?
No, Your Honor.
All right, the court will issue written findings and rulings in regards to all the matters that are heard today. I am going to contact the parties by email to start looking at some scheduling timelines about getting this matter set for trial. I'll follow up with that, and then once the rulings are issued, we'll get a date set for any other additional outstanding matters. If there's nothing else to be heard, court will be in recess until the court orders for the proceedings.
A wild coaster ride of a court hearing. Mickey does look like he's well over 320, I'd say. He's pushing like 350 is my guess. We'll just have our little look at him while he leaves, because why not? Off he goes with his shackles. This ain't Provo. Oh, Lord. We're having all this chit chat, so I hate to turn it off, just in case. All right, that's it. That's it. Oh, hey, Peter. Oh my Lord, what a wild ride this hearing was. One day you get 5 seconds, the next day you just get a whole slew of stuff. All right, let's go ahead and recap. Let's go ahead and recap from the notes, and we can work through this collectively. Help each other come back to earth after this. I'm stuck on the music stand. They don't even have a place for the witness to sit. This is so crazy. And they have, I mean, they look like card tables set up for the attorneys. They're not in Letcher County. I forget what county they're in right now, but the judge that's assigned to this case is from a neighboring county. Chris Cohron is from a different county, and we are in his courtroom today. So this is not Letcher County, but I'm assuming it's nearby. You know, they probably didn't pick a judge from across the state. And it's just a vibe. It's just a whole vibe. Okay. Like I'm sort of used to seeing little janky courtrooms like this for, you know, misdemeanor court, your traffic tickets, stuff like that, where it's just not really very high stakes, not really a lot going on. To have a murder trial, a murder case in a courtroom like this, just a bit wild. So we just opened up observing, yeah, there's lots of motions to resolve, trying to get that done so we can head towards getting a trial date set. Music to my ears. Music to my ears. We want a trial date because we all No, what happened? It's on video, no dispute. He shot the guy. But all of the big mystery about it is why? Why did he do it? Does it even have anything to do with Ben Fields, the deputy who was running the ankle monitor thing, got the criminal conviction, the lawsuit, all that stuff? So the reason that came out in the first place as related, timing wise, the shooting took place right after Mickey Stines' deposition, right? Within a very, very short period after that. He's being deposed about this case. He's being sued over this case. So it's kind of logical. It's like, well, is that part of what's going on? But then also, there's not a ton of information about this whole scheme and like what was going on with it and stuff. We know that Ben Fields was using the judge's chambers for some of these assignations, but that was after hours. It wasn't like while the judge was there. And so there's no like objective kind of evidence that the judge was involved at all. What there is, however, is there is a reference from when Sabrina Adkins, the plaintiff in the civil case, when she was deposed, she claimed to have heard, I think, from somebody else that the judge was also like part of this scene, that he participated in it. And there have been a couple other statements, not under oath, just like to the media or whatever. As I recall, there was like a sheriff deputy, a former, maybe it's not a sheriff deputy, but a jail guard who was saying, oh yeah, boys club, super corrupt, all this stuff going on. I didn't like it. But it's quite nebulous, not real clear what that means, not real clear, how just credible or substantiated or anything any of it is, which is why a civil trial might have been nice, to get a little bit of a better insight into, what is exactly the scope of this, little corrupt scene that they were running with the ankle monitor situation. So I think that's what they're talking about with the, Team Stines, Team Mullins, basically comes down to, do people think the judge was in on it or not? Because people who think the judge was in on it are going to be, sure, he's a hero, give him a medal, let him out. People who don't think the judge was in on it, didn't deserve to be killed. Nobody really deserves to be killed, but easier to make the argument, I guess, if you've got somebody who is kind of a sex pest than if you don't. So that's like our context here. Finally heading towards a trial date, but obviously still not anytime like right around the corner. When they say we're heading towards a trial date, I'm thinking probably still another year. We'll see. So first thing they wanted to address is that motion to preclude the death penalty. They're going to hold that in abeyance while they go through the resolution of, is there going to be a second psych evaluation and that type of thing. So I think just that makes sense to me, because if the purpose of that motion is to look at, does he qualify under this Kentucky statute that says the death penalty can't be imposed on people with these certain diagnoses, we need all the information about, does he have one of these diagnoses or not? Is somebody going to argue he has one of these diagnoses? Is there going to be a conflict about what his diagnosis is that needs to be adjudicated? So just resolve that at some later point. However, there are some timelines that are like part of the statute to be able to invoke this protection. If I remember right, it's 90 days before trial or 120 days before trial or something like that. It needs to be done well in advance of trial. And so that in and of itself, like, we don't have this motion yet. We don't, the trial is going to have to be at least 3 to 4 months after this motion, assuming that it goes forward. We're starting to already kind of add up grounds for delay. So motion to preclude the death penalty, not addressing that one today. But we are going to start with the motion that the state had filed for the second evaluation. And so the Commonwealth is basically arguing that they're entitled to rebut the defense's claims. He's arguing, these mental health defenses, they have the right to rebut that. But the defense is arguing the way that the statute is set up, it's their expert he was required to go and be evaluated by in the first place. So the way the Kentucky statute is set up is if you want to present an insanity defense or a mental health related defense, you have to get an examination by the Kentucky forensic people. It's people employed by the state for the purpose of doing these kinds of forensic examinations. So it's kind of like a state hospital, state psychiatric type of system. So that's why the defense is arguing this is your guy. Now, it's not somebody that the state went out and chose, at least as far as we know. That's not how the statute works. Statute just basically says, you send it to the psych hospital and they probably divvy it out. But, at the same time, there's an affiliation there. Like, I get it. The guy is employed by the state for a state hospital. Probably 99% of the time, what they produce is pro-state. It just tends to kind of be the case. Very similar situation we have here in Washington as far as how these types of evaluations go down. We have a state hospital system very similarly. You want to pursue these defenses, you need to get the evaluations and so forth. So I can see why they say it is the state's expert, but kind of really technically it isn't. The state didn't choose him to make this report. So his argument, Mickey Stines' argument, is that they can hire another expert to come testify about anything that's already happened, but it's invasive and a potential violation of his Fifth Amendment right to order another examination, like to require him to submit to a whole new series of testing and interviews and stuff like that is not what is contemplated by the statute in his his argument. So you do waive your Fifth Amendment right to a limited degree when you pursue something like this that requires you to cooperate with an expert to do an evaluation. Then that can be used against you. But his argument is that the way that the statute is written is that the Fifth Amendment is waived if he offers it. If he doesn't offer it, then it's not waived. So it kind of sounds like the way that he's describing it is that the ball is in his court as far as whether any of these statements would come in at all. And if that's the case, it seems to me like it can't really be the case, or we wouldn't be the prosecution, the Commonwealth wouldn't be asking for another examination, because if they can't offer the statements. He would have the Fifth Amendment right because he's not offering it, right? So even if they got a really, really good report, it doesn't necessarily do them any good if they can't offer it. So that was a little bit kind of confusing to me, where the Fifth Amendment plays into this under the Kentucky rules at least. But it is a legitimate concern. It is the kind of thing that comes up, sort of an obvious sort of objection anytime the state wants to compel your client to have to answer questions and fill in bubbles and do various checklists and all the different instruments and so forth, to be able to peer into your mind and your personality and everything. Yeah, that's pretty revealing. So To what extent can the state compel you to do that? Not crystal clear to me how Kentucky law spells that out. So he has his own expert, and then there's also apparently the doctor from the state hospital is Dr. Allen. Dr. Allen is who we will be looking for. So the defense's position is that their expert can come in and rebut Dr. Allen, and so presumably like review Dr. Allen's materials and what he did and the statements he got and so forth, and disagree with him or not disagree with him, but not, go through and do the whole thing all over again. Now the state says, well, if there's no law that says we only get one evaluation, what a shitty argument. Okay, what a shitty argument to lead with. There's nothing that says you can't. Well, but there's obvious issues with it. There is a First Amendment or a Fifth Amendment issue, an incrimination issue. There is just a burdensomeness and intrusiveness. Why do you need this? Why is it enough and not enough for you to just go in and critique what the other psychiatrist or psychologist already did? Why is that not good enough? But their position is nothing says we can't, therefore we can. Oh, was not impressed with that position. Her argument on behalf of the Commonwealth was that, they need it because it's their burden to rebut. I'm not quite sure that follows, but there was a case that they talked about, a Benjamin case, where it was the defendant who asserted competency and criminal responsibility defenses. So they conducted an evaluation, but he wanted a second one, but he hadn't articulated adequate grounds for funding until like the day of trial or right before trial or something like that. So it sounds like that case was about a denial of a second exam, but it was, not really factually on point because it's a defense request, it's funding related. And so they're saying it's, the case doesn't apply. They're not asking for funds and so forth. She said that the Fifth Amendment concerns are addressed in the rules that they have, and it says that the statements can't be used against him unless he offers that report. So that's what I was kind of just saying. So if he doesn't offer the state's report, then how does it get in? How does it get in over a Fifth Amendment privilege? Unless they're saying, well, if he introduces his own report, then we can introduce this other report. That seems to be a little bit of a stumbling block for me. So the judge had a question. He wants to know if he does order another evaluation, what's the timeline for it? Concerned about the delay. And the state says, well, their expert is in Indiana, but we can get it set up. And the defense points out, well, our expert should be able to be present as well. I'm pretty sure they said their guy's name was Dr. Rogan, but our sound was terrible. The accents are hard to interpret. And there's a baby crying in the courtroom. And I'm distracted by how shitty the environment is. So I can't guarantee it, but I'm pretty sure anyway, Dr. Rogan, pretty sure that's what his name was. So they would need to coordinate that. Now you get into the herding cats problem with two experts needing to be in the same place at the same time. So is that going to delay things? Oh, almost certainly. The judge interprets the rules. His comment is that he has the inherent authority to do it. It doesn't matter if the law says he can or can't, apparently. He has an inherent authority to order it. How does that reconcile with having a Fifth Amendment right to not incriminate yourself to a psychologist? You see the position this puts him in. This puts Mickey in a tricky position, potentially, because if he doesn't answer, he goes in for this examination and they want him to do X, Y, Z. They want him to, do the series of tests, answer all of the questions. He doesn't want to. Now he's not cooperating. Now he's not, he's not being forthcoming. You know, that's gonna be used against him. That would be bad for him to not do it. If he does answer, does he answer truthfully? Does he answer not truthfully? It just puts him in a little bit of a tough boat where kind of no matter what he does, you know, unless the second examination comes out like exactly the same as the first one, I mean, that's sort of the point for it, I guess. There's just no way that it's going to be to his benefit to really help out with this process. I don't know, the inherent authority, anytime judges are like, I can do what I want, that's a little bit alarming to me. But we're not going to get rulings from the bench on any of these. We got to wait for his written order. And I got to say, his written orders so far have been, I mean, I've found them pretty good. You know, they're well written, based on legal authority. So if he says he's got inherent authority, I guess he's got a basis for thinking that. Probably say that in the order, but kind of suggesting, yeah, he's going to let him do it once again. You know, well, if I did, how long is it going to take? And I have the inherent authority to do it. These are sounding pretty favorable to that request. So we'll see how that goes. So then the bond motion, and this goes back to, again, that weird language, not weird, but just unique language that Kentucky has, where if you're charged with a capital offense, you are not entitled to bail if the proof is great, or the proof is evident, the proof of guilt is evident, and the presumption great. So not just it's a capital case, but it's a really, really good capital case that we're probably going to win. Basically what the standard is. So the defense is arguing you can't meet it because we got these defenses that are decent, that are plausible, that could overcome your capital case, because they're mental health based defenses. They will undermine the intent requirement for murder. It will be an extreme emotional disturbance. It will be a guilty but seriously mental ill. It will be something, we have plausible grounds for something less than capital murder. And that does seem to be what the Kentucky cases, the Kentucky law says about kind of how this bailability question works. That as long as they have a plausible reason to argue he could be convicted of something lesser, he could be, you know, he could be acquitted, but he could also just be convicted of something lesser, then he's entitled to bail. So I do think he's going to get bail because of that. The state wants to admit the recording of the shooting. Yet again, the state is going to be waiving that surveillance video. I mean, that's its case, right? It's going to wave that like a big flag. We fucking know he shot the judge. Okay? We know. We don't need to see it over and over and over again. We already know. The question is why. And so none of this goes to why he did it. They had a little, you know, argument back and forth about the rules of evidence applying at this hearing or not. Defense doesn't want the recording of the shooting coming in. Judge ultimately lets it in. Yeah, these events are the basis of the action. Yeah, they are. It is the crime happening. So he's going to consider that. Oh, we got Sherri Stines called up, and poor Sherri has to stand there at that shitty little band camp music stand to give her testimony with her health problems and her needing oxygen and stuff. They can't even give the poor lady a chair. Mickey is her nephew. She knows him as Bubby. So I do remember this was always kind of an interesting piece of the case as well. I mean, maybe or maybe not. But that Mickey didn't have a particularly good childhood. His parents had some issues. And so he was raised by his grandparents. And the only reason why that's interesting to me is just because, you know, family dysfunction, often related to criminality, and these things often are, you know, they cluster. They cluster. Crime clusters, the people involved in crime clusters. And there's often sometimes some overlap between the police force and the kind of background they come from with the people that they're policing. It's not really that uncommon. I don't remember why I talked about this fairly recently, but it's almost like one of the kind of archetypes for a cop is the kid who comes out of the foster care, you know, pulls himself up by his bootstraps and you know, beats the odds and goes on to be a police officer in his own community. Anyway, that's, you know, kind of sounds like Mickey's story. So Bubby was raised by Mama Bones, grandmother and grandfather. Sherri is 62. Mickey is 45. Mickey is 45. He's not. He hasn't aged well. I'm sorry, Mickey. I'm sorry, Mickey, but he doesn't look great. To me, he looks a lot older than 45. But she is 62. Gotta admit, she looks quite a bit older than 62 to me as well. But we have longevity in my family, and my perspective could be a little bit skewed. So she saw Mickey on September 18th, 2024. This is so the night before the judge was shot. Mickey came over to their house late in the day. She doesn't remember exactly when, just that it was not quite dark. It wasn't light, but it wasn't quite dark. He was going to stay the night there, which was not a common thing for him to do. It was an unusual thing, but he had been a nervous wreck, couldn't sleep, and so he was going to stay there so his wife and daughter could rest. So it sounded like he'd been bothering them, I guess. He was disrupting their home situation. So he brought a bag with some tuna creations and the melatonin and the Benadryl. Melatonin gummies and over-the-counter Benadryl. The doctor had told him to take these because he hadn't been sleeping for 7 days and nights. That's the report. So they had their supper of pork chops and green beans. Not the tuna creations. The tuna didn't enter back into the story. I guess I should take this banner down, huh? The tuna didn't enter the story. The tuna creations are those ones right in the little packet. I take them sometimes on the backpacking trip. They have like different flavors and stuff. I got to tell you, honestly, the flavor is awful. Like they're terrible. The only reason to take the tuna creations on the backpacking trip is just because they weigh less than, you know, a can that's packed with water or oil or whatever. But they're not tasty. Like I don't know why you would eat this if you don't just need like cheap protein on the trail that's light. So maybe that's why the tuna creations didn't stay in the story and they had the pork chops instead. But she describes him as real fidgety. And so then she, after dinner, she takes oxygen. So she was sitting in her recliner, taking the oxygen. She told him to go lie down in the guest room, try to get some sleep. But then he was right back in the living room, said he just couldn't get to sleep. So he was watching the security cameras at his house on the phone. He's got Ring cameras or whatever. He's watching the app. He took about 3 or 4 Benadryl and about the same amount of the gummies, but it didn't have any effect and he wasn't able to get to sleep. He was very paranoid. He thought somebody was going to be around the house. Didn't really know why. He didn't mention any specific threats. She knew that he was under a lot of stress and pressure. He just had his deposition taken. And she could tell by how he acted that it was bad, that he was scared to death and didn't know why. Now she has her own theories, but the defense redirected her from articulating those theories. But we're all dying to know the theories, right? Isn't that kind of what the case is about? Why was Mickey behaving like this? Was this legit? Did he have a reason to be concerned? Or is this just paranoid delusions? And we're still like, Mickey's kind of trying to have it both ways with that. You know, both he was paranoid and delusional and psychotic, and so entitled to mental health arguments, but also at the same time, all this really bad shit really was happening and he really was unsafe. So he didn't go anywhere that night, but he did try to get her to take him back to his house so that he could look around. But somebody who I was not able to hear who exactly it was, other than it was a junior in high school, was at the house, was staying in the bed. And so it would have required them to leave the high school kid alone in the bed. And so they didn't do that. And normally Mickey would never even ask. It would never even occur to him to be like, we should a juvenile home alone. I mean, a junior in high school doesn't really seem that young to me to be home alone, but I don't know. Seems like people get up to all kinds of crazy stuff in Letcher County, so maybe it's better that way. He saw a guy that was walking down the back street, the alley behind his house, and that's what like triggered him to want to go back to the house, because he was afraid that somebody was going to hurt his wife and his daughter. Now, normally she describes Mickey as a good guy. He's a jokester. He likes to play. He's a little hyperactive, but he likes to help everybody out. And so his behavior that night was different, and asked for one word to describe it. What word would you use to describe it? Well, kind of psychotic. No, we don't think that was coached at all. So much of this this questioning, I'm like, where is the foundation for any of this stuff? No, nobody's objecting. So perhaps this is normal in this courtroom. But like, what is the foundation? All respect to Sherri. We love Sherri. But what's Sherri's basis for recognizing psychosis in Bubby or anybody else? Could she describe what psychosis is? I just, gotta wonder a little bit how coached that answer was. But Mickey, he never slept, and he left the next morning sometime between 8 and 9. She doesn't remember when, except it was early. Honey, 8 to 9? 8 to 9 is early. Oh Lord. Oh Lord. We were on the stream at 6:45 today, okay? Don't talk to me about 8 to 9 is early. So then he FaceTimed her from the courthouse at 2:49 p.m. They have the screenshot from the FaceTime video. So I had to go and check our timeline because, I know that the judge is shot like fairly soon after lunch. Is this before? Is this after? According to the reports, approximately 2:52 is when he shoots Judge Mullins. So minutes before, we're talking minutes before. He FaceTimes her, and he wanted to speak to Bones, Mommy Bones, the grandma. But the problem is that Mommy Bones has been dead for 2.5 years. He says, let me call you back because there's a bad connection. But then apparently he never did. And as we know, the afternoon unfolded in a much worse way. So this concerned her. This call concerned her because he asked for Mommy Bones twice, but he was with Sherri when they had to unplug Mommy Bones from the respirator. He knew Mommy Bones was gone. So this was, a weird ask. it was kind of hard to watch this part of the testimony just because you could see like Mickey is pretty upset, you know, and this has got to be hard for her to recount as well. You have this like double layer of pain and grief here with the having to take mommy bones off the respirator. But then also, you know, everything that unfolded with the judge and everything that happened since. So fairly emotional, even in the what kind of looks like a somewhat drugged state that Mickey seems to be in. He has apparently been on antipsychotics. No idea, of course, what his current situation is, but there have been references in some of the other court documents that, like, right after he was jailed, they put him on antipsychotics, and he, you know, seemed to respond favorably. And so, you know, so I think part of the basis for concluding that he's potentially got some kind of a mental illness. But you know, they most of these drugs, the antipsychotic drugs, tend to be I don't even know what the right word is. They're like tranquilizers in many respects. Very, very sedating, very heavy sedating effects. And of course, like managing the dose gets to be a whole complicated thing. And so they're often tweaking it because, you know, a little bit too much and you're kind of like a zombie, not enough, and you're not getting the benefits from it. So also very commonly associated, many of them with weight gain, metabolic changes, and things like that. So Mickey is looking a bit, I mean, he's never been a slim man, but anyway, total speculation, but just from his appearance, a little bit wild-eyed, a little bit slack-jawed, possible signs there of being under some antipsychotics. But even in spite of all that, you know, this was a little bit emotional, talking about that last call about mommy bones. So he had never acted like that in the past. It was about within a half an hour that she then found out about the shooting. Mickey had never been violent. He wasn't a mean guy. She doesn't know about him ever discharging his weapon. Not uncommon, even in big forces, for police to go their entire career without discharging their weapon. She told the police, she did talk to the police about what had happened in the days and hours before. She still has the Benadryl and the melatonin at her house because the police spoke to her on the phone, but they never came to her house. So she's never turned it over. I don't know that they really care that much about the Benadryl or the melatonin, but I don't know, maybe you'd want to test it. Just make sure it's not, I don't know, spiked or something. Maybe it doesn't matter. So she continues to FaceTime Mickey at the jail, but not as much as she used to. He's not doing good at all, she says. Now, here's where it got interesting. Very interesting. Because we finally have the California encephalitis entering the chat formally in this case, and not just the kind of side reference in his deposition when he was not remembering certain things he was being asked about. And the explanation for that was, well, he has these episodes as a result of the California encephalitis. She says he has always had to take antibiotics every day because he has an infection in his head. Always had to take antibiotics every day because he has an infection in his head. This sounds like it's a very long-standing thing. And so I'd love to know, was he a kid? Like, that would make California encephalitis make a little bit more sense if he got it when he was a kid, because it normally only affects kids. Very rare disease, tends to affect kids. Not impossible that an adult gets it, but just, you know, extremely rare. She attributes it to a tick bite. He got a tick bite. That's not how California encephalitis is transmitted. It's a mosquito-borne disease. So there's something off there. But if he's getting antibiotics, there's a doctor involved. Somebody has diagnosed it. Somebody has prescribed it. And back when I first started looking at this whole California encephalitis thing, like that was kind of my focus. I'm like, I need to see where a doctor said this. Like, where did a doctor say this? Because it just seems very implausible. It's not from ticks, doesn't affect adults, doesn't typically present in these episodes. But at the same time, it's like not real common. And who knows, diseases can evolve and stuff like that too. They can present in different ways. If it's not really common, maybe it's got different ways to present. And you just happen to be the first one, that it manifests in this way. But so normally California encephalitis, from what I was, reading up about it, it's an acute affection. Like it's literally your brain swells, but then it goes down and it goes away, and there tends to not be significant after effects. That's not at all what he's described. He's described having these recurring types of issues. But he's got an infection in his head or a tightness in his head. He went to the hospital so much, and they acted like it was a big mystery until they ran a test and they found out it really was something. Not a lot of detail here, but it does give some, at least secondhand medical substantiation to him being diagnosed with California encephalitis. Now, maybe tick bite, maybe that's just him making that up. Maybe, maybe he remembers being bitten by a tick. It's disgusting. It's going to maybe stand out in your mind a little bit more than being bitten by a mosquito. Been bitten by mosquitoes, hundreds of times. Who remembers any particular one? A tick bites me, I'm going to remember, because that doesn't happen very often. And then you got to get it out, and it's really foul. And ticks are disgusting. I mean, mosquitoes are too. Part of the reason why both of them are like disease vectors is because they have anticoagulants that they inject into you. I think ticks also have like what's the word I'm looking for? Like, so you don't feel it. You don't feel when they burrow their little head in. Anyway, so they're injecting stuff into you. It's like literally bleh, like the bug is like vomiting a little bit. It's disgusting. So anyway, if they've got stuff, they're already carrying viruses or bacteria or things like that. They can like spit that out into you in the process of giving you the bite. So they're absolutely disgusting. Makes sense to me. You would remember a tick bite, not remember a mosquito. So maybe maybe this is just him attributing it to the tick bite and not the doctor. I don't know. I want to know more. I very much want to know more, because now it sounds like there is some medical legitimacy to it, but it's still just all very strange. She doesn't know much about the symptoms other than tightness in his head. Tightness in his head. What even does that mean? I don't know. And how does that relate to these episodes he described in his deposition where he just would have hard times remembering? It's tricky because on the one hand, it sounds really convenient. It sounds really convenient for him. I'm sorry, I can't answer all of these incriminating questions that you have for me about what I knew or didn't know about Ben Fields and his shenanigans and all of this like other, related stuff that was going on because of these episodes that I have. It sounds like an excuse. It really does. But at the same time, what a weird excuse. Why would you make up this implausible thing? If you were just going to make something up, wouldn't it be much easier to be like, oh, I'm schizophrenic? I don't know. But she says Mickey has always had a lot of health issues. As a sheriff, he tried to help everyone. He would try to give people second chances. He would try to help families out. He doesn't have a passport. He's never left the country, never been on an airplane even, or she would never have heard the end of it. He's never been on an airplane. His relationship with his family is great, she says. There seem to be some questions about his marriage, whether there was kind of some rocky stuff going on with the relationship at the time. Possibly she had maybe filed for a restraining order, something like that. But there hasn't been a divorce filed. So to the extent maybe there were problems before, seems like those have been reconciled. Appeared to be his wife and daughter in the courtroom there today as well. So if he was released on bond, Mickey would be able to stay with her, or he would be able to stay with them. The family FaceTimes with him every day. He's been in jail for close to 2 years now, and he seems pretty back to normal. She says he looks bad, but he acts pretty calm now. Indeed, he does seem pretty calm there in court. So on cross, the Commonwealth attorney, he's a little sharp with my Sherri here. If you're so concerned about Mickey's behavior, but you didn't call anybody, and then when Mickey called the next day, him asking for bones, and she says, "Well, I didn't have time," and he's like, "But you didn't even find out anything happened for 30 minutes," and so that was 30 minutes where you didn't call anybody, being like, "Hey, what's up with Mickey? Is he okay?" He's asking about bones. She doesn't know what he did before coming to the house, and she knows Kevin. Of course, she knows Kevin. Everybody knows everybody, and worked for them, and married their sister in Letcher County. Of course, she knew Kevin, the judge. She's seen the part of the video in the court. She's seen the shooting. Yeah, Commonwealth is going to wave that like a flag, even with somebody as nice as Sherri, who is just there to kind of be there for her bubby, right? Describe what she saw happening with her bubby leading up to the shooting, and they're gonna wave this video at her and, like, make her watch it. Obviously, they didn't do that here, but make sure make sure you've seen your bubby shooting the judge. Nobody disagrees that Mickey shot the judge. Has nothing to do with why. This prosecutor is just being a real asshole with that video to my Sherri, and I didn't like it. On redirect, she says she knew that Mickey had been to the doctor that day. She knew that there were concerns about his mental health the day that he came over and stayed. So then there's also offered by the defense the report of the officer who interviewed Mickey after the shooting. And that comes in without objection. There's no other witnesses. I don't think we've seen the transcript. We maybe have. There's body cam video of this, of him like in the hall afterwards, and he's telling the guys, just treat me fairly, and he's worried about his safety and stuff like that. But also at the same time kind of like knows not to talk. I don't think he invokes, but yeah, it's just this very strange. I don't know what to make of this yet. I really don't. Because on the one hand, Mickey really doesn't seem like the sharpest tool in the shed. And on the other hand, these just seem to be very, very canny, very rational types of behaviors, some of them. Look, the old big butternut Jude is going to come in and say hi. Hi, Judy. That was it. That's enough. Okay, you had your close up. We had argument on this particular motion. So first, clarifying that they can't talk about the psych report in open court, right? Because it's sealed. They wanted to use it, but wanted to at least clarify that the judge is going to be able to consider the psych report as part of their argument. Judge says, yes, they will. Yes, he will do that. So it all comes down to the standard. They have to prove Commonwealth. If they want to not have bond, not have bail, then they have to prove that the evidence is proof of guilt is evident, or the presumption great. And so if the evidence shows likelihood of reduction to a non-capital offense, or at least a plausible argument that that could happen, then they haven't met the burden. So her argument is that the video is compelling, but it doesn't show, or not her, but this was the girl, the woman whose name I didn't catch. She did have great hair, so shiny, very nice. She says, the video, yes, it's compelling. Of course it is. It shows the crime, but it doesn't show the mental state. And that's the part that's necessary, she says, to make it a capital offense. No, it's not a capital offense because of that. But yes, certainly to be a murder at all, mental state is implicated. So the question for her is just if there's enough plausible basis to show a jury would believe that he was under extreme emotional disturbance or insane. And so the evidence here, he was acting out of character. He was paranoid. He was, behaving in these strange ways, points out that extreme emotional disturbance isn't an objective standard. It's not, would a reasonable person under these circumstances be really alarmed and act out, in a volatile or unpredictable way? It's not that at all. It's purely subjective. It's, did this guy act under the influence of, a strong emotion? And so it's kind of your heat of passion type of thing, but just a little bit broader in Kentucky. And so, pretty normal for heat of passion to be a reason for a killing to not be a murder, to be something like a manslaughter instead. Seems like this is fairly similar. So the point of the defense, it's not about was it reasonable what he was doing. It's subjective. It's, what did he feel? Was he in fear? Why was he believing his wife or daughter was in danger? Yes, we all want to know these things. This is why we want the trial date. They point out that the Commonwealth hadn't filed a death notice yet. Don't know that it matters. It's, capital whether they choose to pursue death or not. The judge wants to know what bond they are proposing. They proposed $50,000 cash or property. That is shameful. That is absolutely not going to happen. $500,000 minimum, minimum. It's got to be $1 million bail for a murder like this, caught red-handed on camera in the act. It doesn't really matter if your risk assessment is 0, you have no history, no basis for thinking, oh, he's going to run away. He doesn't even have a passport. It doesn't matter because the nature of the crime itself is quite serious. And you run into sort of the risk, don't you? A little bit of a double-edged sword, I think, with this mental health defense. They're like, oh, well, there's no reason to think he wouldn't appear. Well, what if he doesn't take his meds? What if he decompensates? That's going to be potentially a problem, isn't it? Let alone, if this is all some canny malingering thing. If it is, he's doing an absolute great job of it because seems to have the medical people on his side. Oh, this case is just crazy. But they are totally fine with there being conditions on him, including the ankle monitor. Oh, I bet he is just fine with the ankle monitor. That's probably, being run by one of the deputies that he's probably known for decades. And in this program that has a history of doing little inside favors for people. Oh, yikes. No firearms, that would be okay too. The state's position is, well, these are just all defenses, and that's not the point where we're at yet. Well, it kind of is. Like, I mean, I read some of the cases. I'm not an expert in Kentucky, but I read some of the cases, and yeah, it seems pretty crystal clear that a viable defense is exactly what this issue is about. That if it's a capital crime and there's no like obvious pretty decent defense, you're not getting bail. If there is a plausible defense, you are. So he's like, they're not there yet, but that's not what the law is, dude. He pointed out this case, State versus Jones, where he says in that case, the Commonwealth chose not to seek death and a bond was granted. And the case says that the court must make an express finding about whether the proof of guilt is evident or the presumption is great. Okay, it sounds like he's got a pretty good basis to find that there's a plausible extreme emotional disturbance defense, if nothing else. The reason why it's a capital offense is because Mullins is a public official. That's the aggravating circumstance that elevates it. But bottom line, they believe he's not bailable. They think he's not bailable. Terrible argument. I think they're in a really bad position here. The law is not on their side. He's going to get bail, guys. He's going to get bail. But the judge reassured me 50,000. He will not entertain that. That's not going to be an option. It would be much more than that if he does grant bail. That's relief, I guess. Jude, give me half a second here, guys. The cat's over chewing on my my sheet music on my piano. Judy, come here, bud. He's not going to come, but I at least distracted him from it. We then moved on to the change of venue. We've seen a lot of changes of venue recently, haven't we? And like things related to changes of venue. Saw it in Coburger, that really slick pretrial presentation. The jury survey that Dr. Edelman came in and did, lots of data, scientifically conducted. Similar developments already starting to happen in Provo, in Tyler Robinson's case. Not that anybody has moved to change venue yet, but analysis of the publicity and the effects on the jury pool. Same type of thing, very data heavy. Not at all what we're getting over here in Letcher County. We do not have data. We have opinions and anecdotes. So first we have him telling us about 103 articles on the case that are in the Mountain Eagle, who has, by the way, 30,000 followers on their Facebook page. And there's been lots of news coverage and comments on the case. What else is new? What else is new? That happens like all the time. Yes, this one's extensive, but what makes this one unusual, I would suspect, is not that it's talked about in Letcher County, that it's talked about outside of Letcher County. It's that I, sitting over here in my tiny little community, well, it's not that tiny, but my small community over here in Eastern Washington, that these guys have never heard of. Okay. The fact that I have now heard of Letcher County at all, that's what's extraordinary about this. It's me. It's not the county. I bet the county talks about their own crime all the time. Maybe not to this extent, though. Who knows? And so, it's just that a large number of the community has strong feelings about the case, one way or another. Also not really surprising. Kind of, in a way, I think kind of undercuts his own argument a little bit by pointing out, it's not just Letcher County either, Judge. By the way, I talked to a guy in this other county, like a nearby county. I think it's Is it Pulaski? I couldn't tell what the county is. I wrote down Pulaski, and I wrote it down like that because maybe it's got some connection with the Pulaski tool. You guys know the Pulaski tool. It's the wildland firefighters use it. It's like a big, long axe and hoe kind of thing. Use it for cutting fire lines and stuff like that. Anyway, it's named after some person. I kind of think maybe they're the same name anyway. But that guy had an opinion, right? This one guy that he talked to in another county had an opinion. So, and then there's the YouTube. Oh my gosh, you guys, the YouTube and the bloggers, the coverage has just been crazy. It's just been crazy. The YouTube. It's always YouTube's fault, isn't it? But YouTube isn't Letcher County. Don't know how much Letcher County is tuning into the YouTube. That would be the kind of question that somebody like a Dr. Edelman would be asking to get data to establish how pervasive and persistent are these problems beyond just, I talked to a guy in the next county and he had an opinion. QED. It's just a super, super rinky-dink argument. That's their basis. News coverage is crazy, and we think it would be hard to find people that don't have opinions. So then the defense decides to call the witnesses, and they're calling people who have submitted affidavits for the Commonwealth in support of the change of venue. So these are not the defense's like friendly witnesses. These are hostile witnesses, like technically, that they're calling. Well, I guess maybe not technically. They're not hostile, but they're not the witnesses that the defense, presented. So first was Ashley Sturgell, who is an attorney in Whitesburg, who's been there for 3 years, has a general practice. She was in the courthouse the day of the shooting. So yeah, she's sort of a witness. She's sort of a witness. She was shook up by it. She provided an affidavit in support of the state of public opinion about the case. We had that chunk of time where we lost the sound and don't know what they were saying during that part of the questioning. But when we got the sound back, we're talking about her doing criminal defense and being aware he gets presumed innocent. But either way, she doesn't believe either party can get a fair trial because there are lots of strong opinions on both sides. A lot of argument back and forth about, isn't voir dire going to handle that and stuff? A lot of these arguments we've been dealing with in Tyler Robinson's case. That's the presumption, is that in and of itself, having knowledge about the case isn't the problem. The problem is whether you can put it aside and decide the case fairly based solely on what you hear in court. Good arguments to be had about whether that is even actually possible, but at least in terms of the legal fiction that we operate under, the legal fiction is that yes, you can. If people say they can put their opinions aside and be fair, then they can in fact do that, and that is good enough. But as far as bias, she doesn't think that people will admit if they're biased. Like, who's going to admit they're a racist? A lot of biases you don't even know you have. Yes, very much the case. She's never been a county attorney. I think the defense was maybe a little bit curious, like, why are you a defense attorney helping out the prosecution in this case? They do tend to be like teams, talking about team. They talked about Team Stines and Team Mullins. There's very much team defense and team prosecution in pretty much any given courthouse. So he seems to be questioning about, like, what team are you really on? She's never been a county attorney, but she doesn't know the population of Letcher County either. Doesn't know how many people she's talked to about stuff. Like, I was really not impressed with this witness. It's like, great, you have an opinion, but there was nothing in it about the basis for her opinion that made it sound like anything more than, yeah, well, that's just your opinion, man. You know, she's talked to some people. And they kept trying to elicit, well, like how many people? Yeah, I don't know. I don't know how many people I talked. I talked to lots of people. So it's this way of kind of making herself an expert about public opinion. But again, with the lack of foundation. No idea what her foundation is supposed to be, how this is good, how this is not just anecdotal. Maybe the people that she talks to are skewed for one reason or another. Maybe if she's on team defense, she's naturally going to be talking to people who are more team Stines, team Mickey. And so she's going to hear more of those opinions. Possible. I don't know. None of this has been laid out. She's just sort of dumped up here is because she's an attorney who talks to lots of people, that therefore she's an authority on what the county thinks. And as it turns out, she was in the running to take over Judge Mullins' seat. Ultimately didn't get it. Wasn't, I guess, a good gauge of that opinion. They have like a commission that goes through and does the appointments. It wasn't like a vote or anything like that, but yeah, I was not real impressed with Ashley Sturgell myself. But she did have, again, glorious hair, glorious, long blonde, looked like Erica Kirk kind of hair. Very beautiful, but not real impressed with her opinions. The state with that pompous bullshit. Okay, I was thinking about it. I gotta look real quick, see if I can find my case. I don't remember the name of it, which is always the challenge. Yeah, boy, I don't remember. Not going to find it on a short thing like that, but that's so it came front and center in my mind. The prosecution has to start, oh, well, we're in a different position here because he's over there interested in his client, but I'm worried about justice on both sides. Oh, gag me already. Sit the fuck down. Who the hell is this guy? Who's this pompous piece of shit think he is? You're concerned about justice for both sides. I call bullshit. You are not concerned about justice for Mickey. You're concerned about getting a conviction that will hold up on appeal. That's it. Whether it's just or not. That's what you care about. Fuck this guy. Oh, that pissed me off. I'm concerned about justice for both sides. Not like them. My case, it was something along the lines, very similar framing. The defense is just worried about their client. I'm interested in the truth. And our experts are interested in the truth. They're experts. They're for the defense. They got a different thing going on. They just want to help him. But we're about the truth. One of the grounds for this was a case with like pervasive prosecutorial misconduct. And so there wasn't like one specific thing the prosecutor did that got the case reversed. But that was among the things that got called out. You don't get to do that. That's some bullshit. You don't get to disparage them. Like they're here to lie to you because they're just interested in their client. Ugh. We had a little sidebar. I don't know that it was as a result of that comment, but anyway, they had a little sidebar. And so when we came back, he is questioning Ashley, and just her perception is that, there's a mindset that's for and against him. On average, how many people does she talk to a week? She doesn't know. She doesn't seem to know. Like, she doesn't know foundational stuff. She's worked in Letcher County since 2019, so she hasn't really been there that long. Relatively speaking, you know, she is still a new person to this community. I mean, we're gonna, the very next guy we're gonna hear from, you know, lifelong Mickey, lifelong. Suspect a lot of the Letcher County people been there their entire lives, and then she's Johnny come lately coming in as the expert on the public opinion. It kind of makes it a little bit harder to believe, but I don't know. But she knows lots of people, guys. She knows lots of people. So the case comes up often in conversation. I imagine that it does. And she believes the people in the community have strong opinions on guilt or innocence. I don't doubt that some people do, but the issue is how many and how strong. And that's where the data was so helpful in Kohberger. Because you can get a representative sample and not just a sample that's kind of skewed by who you happen to know and who you happen to talk to and who happens to trust you with their opinions and stuff. Yeah. She says there's lots of rumors going around the community. Some people say he should be free and that he should be given the key to the city. He's heard those. Those are the, you know, Mullins was in on it type of viewpoint. And that includes, you know, both people that she knows and people she doesn't know. She's heard or seen comments from. It's considers it a very divisive case or situation in Letcher County. Which I think highlights why the defense wants it there, right? They really do, because if it's very divisive and there are people with strong opinions, Mickey deserves a key to the city, even if he did do it, kind of thing. They're going to nullify. Then you have a great shot at a hung jury. You know, great shot at a hung jury. Somebody very opinionated who will not change their position and will get in the way of a criminal conviction. Defense has a few more questions for her on redirect. She has been doing criminal defense since 2019. She does it in other counties too, but she is not a public defender. Asked how many changes of venue have you asked for? Really blew her credibility with me at this point. The humming and hawing. Well, I'm not sure. I don't really remember. I can't say. And then eventually comes down to I haven't in a criminal case. I haven't. You would remember if you had. You would remember if you had, because it's not number one, not a common thing to do, because it's not that common to have a case where you need to ask for it. It's not that common to have high profile cases. Granted, publicity isn't the only reason to ask for a change of venue, but it's probably the most common one. And there's a process. It's difficult. You know, you have to make your showing that, you know, here's all this press, and maybe you don't do the whole thing like Kohberger did. But it's going to stand out because it's not an everyday thing. So all this humming, I'm not sure. I can't really quite remember. Oh, well, no, you haven't. Okay. Just say it. I never have. It's fine. Would have been way more believable than this humming and hawing as if, you know, she's trying to kind of soft shoe that she did in fact do some, but she just can't remember the details. Yeah, no, you didn't. But she has in other cases. I would have loved to have followed up on that. Give me an example. Because changing venue in like a civil case is a whole different thing. When you're changing venue in a civil case, it's like rarely because of pretrial publicity or things like that. It's because of like jurisdictional issues or multiple defendants or forum non-convenience. Like they're for different reasons. So I would have loved to have gotten a little follow-up on that, just to kind of dig my finger into that whole, like, you're up here sort of presenting yourself as an expert. You've inserted yourself I mean, I don't know that she volunteered, but she was willing to be inserted as an expert on Letcher County, having lived there for 7 years, and talked to some people. But she's going to hum and haw about her own experience. She's never, in fact, filed a motion to change venue like this. It's just, it's a good pathway. Good pathway for cross-examination. I would have liked to explore that a little bit. Other situation, and so maybe like in a family case where, yeah, somebody moves, or the people live in different counties or whatever. The kid's going to go to a different school. I mean, can see cases like that. But those are different contexts. Those don't have to do with public opinion and publicity and stuff like that. She's never had a case where the Commonwealth asked for a change of venue. Sounds like this is unusual, even though Kentucky law does explicitly allow the Commonwealth to make this request where other states may not. Where would it go? Say the judge grants it, where would it go? Well, I'm not in charge of that. I'm not in charge of that. The judge wanted to know if there's anyone that she's ever talked to that has no opinion about the case. And she says no. No, nobody that she's talked to that has no opinion. She's in the courthouse at least every week. She says some people, want to ask questions or whatever, but for the most part, the majority have formed their opinion already. Then we get Jamie Hatton. Jamie Hatton. He lives in Whitesburg also. He is the Letcher County attorney. He didn't recuse himself from the prosecution because it just didn't come up. It just didn't come up. He was also Mickey's attorney at the time. This guy has like conflicts from every angle. He was Mickey's attorney at the time. Wild. Anyway, he's talked to lots of people too, and nobody that he's talked to has said, I won't believe what the Commonwealth says. I believe Mickey is not guilty and I won't change that. Nobody is saying things like that to him. But he doesn't know if people could be fair, and he also doesn't know if people would say that they couldn't be fair, because that's just not how jury selection often works. From the state, the Commonwealth, we learned that he's been the county attorney for 15 and a half years. So he was the county attorney when all this happened. He spent his entire life in Letcher County, except for the 8 years that he was in school. In a week, he might talk to 100 or more people, was his estimate. He is also in private practice. I guess being the county attorney is not a full-time job there in Letcher, much like being the deputy. It's not a full-time job, so that you could also be the electronic home, release person, run those two jobs. He said in about the first year, the case would come up all the time. It was like all anybody would talk about it. And if he was in court with another county, as soon as they heard he was from Letcher County, they would want to talk about it. And then continuing every time there's a hearing, it brings it all back up. People want to talk to it again. He subscribes to the local newspaper. He sees the article. We heard about this Speak Your Piece. Speak Your Piece is apparently this column in the local newspaper. He describes it as like a local opinion thing where anybody can call in and leave a message and they'll post it in the paper. And the judge seems a little incredulous to hear this. He's like, you're saying people call in anonymously and they publish it? And he's like, oh yeah. It's like a whole column. I want to go look it up now. I want to see if it's online. Is Speak Your Piece online anywhere where we can see? I would love to know the kinds of things that get called in Letcher County anonymously and published in the newspaper. I'd love to see some of that. Maybe I'll follow up on that. He says he couldn't say, a percentage of who's made up their mind or who hasn't, which does seem to be kind of an important question vis-a-vis, can you get a decent jury pool or not? You need to know how many people are fixed, how many people are still open. Because if there's enough open people, you don't need to move it. You just need to find ways to be able to identify those people. But to him, there just seems to be a very strong Team Mickey and Team Mullins. The lines have been drawn and people are on sides. Both of them seem to be pretty rooted in their position. So because of that, in his opinion, the change of venue is appropriate. He thinks, well, you could, he made this comment, you could just bring the circus back, but you'll end up having to change it eventually anyway. And I think this is going to the argument that, well, you don't know if you can get a fair jury until you bring in the panel and you ask them and you start your selection process, which is kind of the normal default way for how these change of venue motions go. Jury panel comes in, you find out nobody can be fair, so you bring the motion and then you get it moved. That seems to me to be what he's referring about. But boy, the circus. Defense elicits that besides being the county attorney, he's also been a public defender. I hope not simultaneously. I really hope not simultaneously. Even in other counties, I feel like that would bother me. Knowing my public defender was prosecuting people in another county. I don't know. It's not like a strict conflict, I guess, but I wouldn't like it. I wouldn't like it. He has never filed for a change of venue. It's the first time he had ever seen the Commonwealth move for a change of venue. He was also, this is like casual Friday there in court. County attorney is showing up without a jacket and stuff. Just can't help but notice these things. They call for Matthew Butler, but he is not present. So we have the sidebar and then the recess. And apparently the deal is he's not in court, but they got him in on the phone. So then we have Matt Butler testify. He's also a Commonwealth attorney. Has been since July of 2024, so just shortly before the shooting. So he's with the prosecutor's office, but he's also a witness. The prosecutor's office hasn't recused themselves, but the AG is running the prosecution. But if the county attorney isn't recused, are they sealed off from it? I don't know. I got a billion questions about how all this is working. He also has never asked for a change of venue as a prosecutor. His view, he says it's a case-by-case approach. And so if the defense moved and they couldn't get a fair trial, I wouldn't object to it. Sorry, I don't buy it. I don't buy that. Just goes hand in hand with that last up his own ass prosecutor. Oh, I'm about fairness I'm about truth for everybody. I'm not buying it. And like just the fact that you would say that at all tells me you're not about that. The fact that you are yelling this so loudly makes me like even more convinced that you are just trying to win your position, whatever it is. I wouldn't object. I would love to probe into that as well. So how many change of venue motions have defendants brought in your cases, and how many times did you object? Don't know if it's ever happened, but I would like to know. Anyway, what is a fair trial for the Commonwealth? We got our Clinton-esque moment. Well, it depends on how fair is, right? Depends on what the meaning of fair is. What's a fair trial for the Commonwealth? He actually had a pretty good answer. I thought his answer had it ready where both parties, both sides have just as much of a shot at getting an impartial jury. Now, I would expect as a county attorney, as a prosecutor, his perspective is going to be a little bit skewed because he's going to be used to the kind of normal situation, which is where To the extent there's any media about this at all, it's probably relatively small, but people have heard, oh, so and so got charged with stuff, and with X, Y, and Z. The police blotter maybe in the newspaper, oh, so and so got arrested for burglarizing the gas station or whatever. And that's what they're going to know. They're going to come into the jury selection knowing, oh yeah, he broke into the gas station. But I can totally be fair and presumed innocent. That's the state of affairs this guy is used to, where people come in already kind of knowing, maybe some of them already kind of knowing a little bit about the accusation, probably having a little bit of an opinion, but oh yeah, we can totally be fair. And so in his mind, that's the defense having a fair shot at getting an impartial jury. This is just my suspicion on how all this works. But yeah, I tend to think his baseline might be a little bit skewed. Nevertheless, I think that is a fairly decent answer, as far as it goes. What's a fair trial? Well, they both have just as much of a shot at getting an impartial jury. In his view, there is no way to seat a jury in Letcher County. In this case, he lives here. He has seen, he's not happy with the defense lawyers. Now we're seeing the teams again, right? The team defense, team prosecution. I've seen concerted efforts by you and your investigators and others to taint the jury pool, to imply that there's some kind of conspiracy going on. Seen efforts by you to taint the jury pool. I don't know that I would go that far. Of course, I haven't seen what he's seen. But yeah, there are certainly some muddy waters, aren't there? Certainly some muddy waters. And kind of the defense is still holding its cards quite close. We don't know if he's saying Mickey was paranoid because all this shit with the judge was, the ring and the judge being involved in the corruption and stuff was true and was real, or Mickey was paranoid because he's mentally ill, and he just happened to fixate on like this one thing that didn't have like a good basis. It's not real clear. It's still really not clear, and they've kind of kept the door open both ways. We saw that with the motion to disqualify the judge. They're like, you are going to learn things about Judge Mullins that might be inconsistent with your professional view of him, might make you disinclined to believe these things. So he does seem to be that he's going to push, based on that, the idea that Mullins was involved in all this stuff with Ben Fields and the corruption. I don't know how he's going to establish that. And it gets a little tricky, like, okay, maybe, I don't know. He can always testify himself, right? Mickey can always testify himself. But it puts him in a bit of a sticky situation if he knows about Judge Mullins's quote unquote corruption, alleged corruption, and he's never done anything about it. And he's the sheriff. Like, is he also complicit? That's why this whole thing is really so murky and messy. So I think that's kind of what he means by tainting the jury pool. But the defense didn't create that stuff. That's it came out of the civil trial. It came out of some of the media and things like that. But they clearly don't like it either way. Having a defense and expressing that you have a defense to somebody who is used to the framework where the jurors coming in are only going to have been exposed to the prosecution's case, then perhaps it would be tainting the jury pool for those same people to also realize there might be a defense here. Within an hour of your client shooting the judge, I'd spoken to the attorney general and agreed it would be better for a prosecutor outside Letcher County to handle the matter. Yeah, that's good. But if Letcher County hasn't recused, are they walled off? Do they still have their fingers in this at all? I would really like to know. It's such a simple thing to do. to just not raise any questions at all, just freaking recuse. You guys are witnesses. You guys are directly involved. You guys are so, close to the action on this one. Why would you not just go ahead and do that formally? I really don't know. And that's what makes me a little alarmed. But maybe it's just because it's just more of the rinky dink kind of practice. Oh, it never occurred to me. Maybe I should just say, it doesn't matter. Yeah. Kind of goes hand in hand with the types of presentations we're seeing from them so far. I don't know how much is malice. I don't know how much is marginal competency. I don't know how much of it is just pretending to be dumb. I don't have a good read on this case at all. He is also related to Judge Mullins, or was at one time, because they were brothers-in-law. They were married to a pair of sisters. He married one sister. Mullins married another sister. Don't know what happened with that, but apparently, well, obviously it's no longer the case because Mullins is no longer married to anybody, but it's not clear to me if he was saying the death terminated their relationship or somebody got divorced. I don't know. He did not practice in Letcher County at that time, so I guess it was before. I don't know. And that was the evidence. That was the evidence. Is some people say can't be fair. People have strong opinions. There's lots of media. Got it. Definitely a situation where I think if this was a defense motion and the defense had put on this kind of presentation, we would be getting the ruling from the bench saying you haven't met your burden. We can call in the jury pool and see. If the defense is asking for it, to me this is a pretty easy one to say. Can't make the finding that just because people have opinions, we don't know about the scope of it, we don't know about the reach of it, we don't know about the strength of it and stuff like that. So you have to go or at least start the jury selection process to figure that out. But it's not, of course, it's the state, and so it's the Commonwealth. So seem to be getting a little bit more favorable handling. Now, having said all that, should this trial take place in Letcher County? Absolutely freaking not. Okay, absolutely not. I understand why Mickey wants it there. But for apparently him not having a kind of vicinage protection in Kentucky, like he might have in other states, then he'd be able to stand on that and get it, because the state wouldn't have a basis to ask for it to be moved. But Kentucky is different, so at risk of losing that venue that he clearly, it's clearly favorable to him. If all of this is true, clearly favorable to Mickey. Very hard to get a conviction of Mickey. Of course he wants it to be there. Defense's argument, just the mere fact of hearing about a case isn't enough. That's true. They're going to apply, the defense is going to take the standards that the state, the Commonwealth is like always going to invoke in these cases and turn it right around on them. Right? The same arguments the Commonwealth always makes are now available to the defense. The fact that people have heard about it isn't enough. It's about whether they can be fair, whether they can put aside what they heard. He brought up these other cases he'd been involved in, one with 2 robberies and 2 murders, and he moved for a change of venue and it wasn't granted, and they were able to get a jury, and he didn't agree with that, but he was pretty much told in that situation that reading about it and talking about it, those don't matter. Yep, that's the standard you're going to be subject to as the defense. Having knowledge about the case in and of itself isn't disqualifying. It's whether you can be fair. And so as long as people can walk into the courtroom and say the magic words, I can be fair and impartial, they can, legally speaking, be qualified to sit on the jury. He should have the right to be tried in his own county, in his home county. In many places he would, but apparently in Kentucky he does not. Several years ago, mentions this case again. I think this is Pulaski County, where the sheriff was assassinated. It was a high profile case. He didn't really spell out why that mattered. So did you move the jury in that case or not? It really wasn't clear. But he basically said, unless you try to get a jury and then you can't, that's when venue should be raised. That's the more appropriate way to raise it. That's typical. Got to say that's typical. But also got to agree it's not necessarily very efficient, because sometimes you can just kind of know, like it's sort of obvious it isn't going to work. Sort of obvious it's going to be a problem. Felt like, Moscow, Idaho was pretty obviously going to be a problem. My issue with that one was, and I don't know. My issue with that one was whether they should have asked for it in the first place or whether they should have stuck with Judge. But that's water under the bridge now. So the Commonwealth's argument was that, but the cases that he's talking about, with the seating the jury and reading about it is fine. That was pre-internet. Those were pre-internet cases. Those were in the 80s and the 90s. I don't know why that it doesn't matter in terms of it doesn't affect the standard. Can you be fair and impartial doesn't change with the advent of the internet. It's just the opportunity, I guess, to read a lot more and to, argue with other people online about what you think. And so today, it's so different because we've got the coverage from the bloggers and the YouTube whatever. Okay, so I'm in my mind. I'm hearing Megyn Kelly. I'm like that back in that debate, right? I'm like, is blood coming out of the whatever? The YouTube, is blood coming out of the YouTube's whatever at this point? A little bit more specificity about why YouTube is the problem here might help. It might help. Go ahead and make your record. What exactly is YouTube doing wrong? How is YouTube like mind distorting your Letcher County jury pool? I don't know. People say all kinds of things all the time. They sort of always have. I mean, that's the internet didn't create these kinds of things. They're what was the AM radio show, right? Big about the aliens and stuff like that. I mean, there've always been conversations and gossip forums and tabloids and just different ways of discussing and vetting these different theories and stuff like that. But Jeff knows what it is. Oh no, he found the speak your piece. What is the one I'm thinking of? Coast to Coast. Yes. Thank you. Coast to Coast. And people would call in with like their alien abduction stories and stuff like that. It was absolutely fascinating. Why that on radio? So it's not like this is new just because of the internet. But then, the problem that I see as like being the real, yes, Art Bell. The real, he was like the pre, this is what happens when I start the live stream at 6:45. Like I have nothing. The words are gone. The names are gone. I can't remember. Alex Jones is who I was thinking of. Art Bell was like kind of Alex Jones before Alex Jones existed. So anyway, then the prosecutor moves on to the point that I think is a very valid point. You are at the crime scene. Okay, the jury is going to be instructed as part of their instructions. Don't go to the crime scene. Don't do any independent investigation. Don't try to look and see where these things happen. But to do your job as a juror, you are going to be entering and walking through this crime scene every single day. And you're going to be around the people who were there at the crime scene, the witnesses. And that part is a little bit sticky. Like, how do you deal with that? How do you have a trial in the crime scene? To me, this is a good point. This is a really good point. Maybe it doesn't matter. I don't know. Maybe it doesn't matter because it's not a situation where there's a lot of dispute about what happened. It's why he's on camera. We know where it took place. We know all this stuff. But it is still just quite awkward. And reconciling that, how does the jury follow their instructions and also show up to do their duty? Their argument, of course, is Team Stines versus Team Mullins. Some strange argument about how the population is going to be less than 20,000 because of a flood, because there was flooding. I don't know, losing population. Not surprising to me that the rural Kentucky is losing population. But also, like, I don't know where this is not in evidence. I don't know where this prosecution is pulling it from. We're back into that's just your opinion, man. And what the fuck is your foundation? Well, I think so. He thinks it's going to be less. Great. The census apparently said something else, but he's going to like predict what the next census is and then base his argument on that. Whatever. It doesn't matter. His view, either way, you need to call all of them. You need to call all 20,000 to maybe get 14. That could be fair. Points to the Brewster case that involves prejudicial news coverage. The defense's response to that is simply that the existence of prejudicial news coverage isn't the end of the story. You have to try to get a fair jury, which is pretty normally the case when you're the defendant trying to get a change of venue. The internet is a big unknown as far as how many people are watching, where are the people from, stuff like that. Yeah, because me sitting over here in my own little corner of the world that you've never heard of, I have no influence over, your community or people's opinions, what happened there. I'm not really part of that conversation. So it's a big unknown, in part because this is such a rinky-dink motion that nobody has gone in and gotten the data for. We would know had Brian Edelman gone and done a survey. We would know, like, how much reach does the internet have in Letcher County? And then, of course, well, where else would we go? This is again the Kohberger problem. It was a worldwide case. Okay, everybody has heard about it. It's not just a localized issue. Everybody has heard about it. And that was what I thought they had handled so well in the Kohberger case with Dr. Edelman and their presentation, because they pointed out all of these other things going on with the local community when a high profile crime happens and it implicates their safety concerns, and they want to believe that they're safe, and there's kind of all these different motivations and things like that that the local community has relative to people that aren't personally affected by a crime. Nobody's making that argument in this case, though. The judge says, well, but if I do grant it, that will be my decision. It'll be up to me to decide, figure out where else we would go. And of course, nobody's questioning the honesty of the jurors in Letcher County. We got to do that little suck up thing, even though, Letcher County isn't electing you, judge, but it's not necessary. The disclaimer isn't necessary, but just had to do that anyway. He's going to review the case law that was presented today, but he is going to be hard pressed not to grant the petition. So he's telling us, yeah, probably going to change venue. He cannot fathom reasonably obtaining a jury in Letcher County with the amount of coverage. It's a very divisive situation. The whole team thing described seems to be intractable, and these things would make a fair trial almost impossible. He's going to issue a written ruling on all of these things. As far as what else today, the defense just wants an opportunity to give input into where the trial would be held if the judge decides that, in fact, the trial does need to be moved somewhere else. We get into more delays, don't we? More delays. The judge decides that the trial is going to be moved, which he has told us is likely, probably going to happen. There's going to be some delay, I would think, inherent in that. Figuring out where there's going to be a briefing process. They're going to chit chat about it. There's going to be a whole just logistical side to it, coordinating with that county. What's your availability? When? All of that type of thing. You got to like find room in another courthouse somewhere and opportunity to use their staff and stuff like that. They've already got their schedule set. Yeah, you're talking about more reasons why the thing gets kicked down the road. So the judge says yes, it seems to be within his discretion. You know, the statute does have this like order of priority, like it's the adjoining county and then counties in the district, and then, you know, I forget, but basically it's based on geographic proximity, and the judge is saying regardless, the trial would need to be far enough from the direct media coverage, kind of how he put it. I think he just means the, you know, extensive, the Mountain Eagle that they were talking about, that's been covering it at length. He says he has wide discretion to pick the destination. So with nothing else, the court is going to issue a written ruling, and he's encouraged everybody to start looking at scheduling timelines to be able to get the matter set for trial. They're going to coordinate about that by email. And so, yeah, I suspect that what they're going to try to do is put together some type of scheduling order, like, you know, dispositive motions need to be filed by whatever date, discovery needs to be completed by whatever date, you know, get that all lined up so that they can have a realistic, you know, expectation of when the pretrial stuff is going to be resolved, so they can set the case for trial. If we don't even have a decision yet on pursuing the death penalty, then yeah, there's some things need to be done before that can happen. And then once he issues his rulings, they'll set a date for any other outstanding matters. So the outstanding matter we know of right off the bat, that whole thing about taking the death penalty off the table based on his mental health condition. So a couple ways that could go. I mean, the state could just decide by itself, we're not going to pursue death, and then that would moot it. There's no death penalty to take off the table, so you don't have to worry about it. Possibility that trying to think of how else it could go. I mean, if they do pursue death, or we're still in just this kind of gray area where we don't know if they will or if they won't, but they go through the new psych exam. All right, he's already got a psych exam, a new one. That would call for a hearing if there's a conflict between them, or if there's an issue of whether a dispute about whether the psychiatric evidence, you know, puts him squarely within the protection of that statute or not. I would suspect that it probably doesn't. Of course, I have no idea. I don't know, but the state has assured me that, you know, if that's how it is, they don't object to things if the defense is, you know, right about it. So we know that that's pending. No idea if they've got other dispositive motions to bring in the vein of like motions to suppress, things like that. Certainly there's always motions in limine going into trial. Not, you know, these are admitting or excluding evidence, not because of like constitutional violations, search and seizure issues, stuff like that. Those are suppression, but various reasons why other evidence might be excluded, hearsay and stuff like that. But that's, typically just going to be on the eve of trial. So don't know what else, if anything, there might be that needs to be litigated before they can get the case ready for trial, and that's part of the reason why they need to, get this scheduling order kind of thing in place and have a conversation about it so everybody can be on the same page about that. But it's not looking real favorable to me for a trial this year. Not looking real favorable for a trial this year. Say, sometime next year is probably a little bit more in the ballpark. Guys, that was wild. I'm like, feel like I need a nap after writing out that hearing. I just can't handle the jerking around this crazy ass courtroom, the straining to hear anything, the bubby, the upper and lower bottoms, the foundation that doesn't exist, that everybody is related to everybody and nobody cares. The rinky-dink presentation that the prosecution is going to get the full benefit of the doubt on because they're the prosecution. And we would absolutely in no way be in this position if it was the defense asking for the change of venue. This was a lot today, man, this case. And then of course, California encephalitis is now in this case. It's now in the case. What, if any, relationship does that have to the shooting? I don't know, man. This one is so weird. It's so weird. This one is super weird. Obviously not impossible that he's got California encephalitis along with some other kind of mental health disorder. It's just a little unusual that psychotic disorders, appear for the first time in your early 40s. Not unheard of. There is adult onset. But it's just once again, like all this really weird kind of rare stuff converging at the same time. Very strange for him to have California encephalitis at all. Very strange to have it attributed to a tick bite. Very strange for it to manifest in the way that he's described. Very strange to have some other independent psychosis, psychotic disorder that just, emerges. It's a weird one, guys. I don't know what else to say. This case is so weird. This case is so weird. And I just, yeah, I mean, I guess we're probably going to have to wait to trial, but I can't figure out. I can't figure out if this is a malingering or if this is legit. I really can't. Because none of it sounds right. None of it fits. But what a weird ass thing to make up. And if a doctor is giving him antibiotics for it, then there's got to be something there. I don't even know how you test for California encephalitis. I assume it's the type of thing where it's like a DNA or RNA type of test. Right? Pretty sure it's viral. Let me check that real quick. Is California encephalitis viral? Yeah, it is. It is. Here's let's just go ahead and pull this up. Why not? Here's what Wikipedia has to say about California encephalitis. Discovered in Kern County, California. Let me see if I can make this a little bit bigger. Yeah, there we go. Encephalitis is an acute inflammation of the brain that can cause minor symptoms such as headaches to more severe symptoms such as seizures. Mosquitoes serve as its carrier. For this reason is known as an arbovirus. A lot of stuff that doesn't fit so far. It belongs to this genus of viruses related to West Nile, St. Louis encephalitis. First discovered in 1943. First 3 cases reported in Kern County. Strong laboratory evidence confirming infection due to the presence of neutralizing antibodies linked to California encephalitis. Since then, most cases of encephalitis have been associated with the lacrosse virus, and California encephalitis is a rare cause of disease in the Western world. Yeah. When I looked at it, I was trying to look at some of the, medical literature, what there is about it, because there doesn't seem to be all that much. I'm pretty sure certainly less than 1,000 cases ever, but I want to say even less than like maybe a couple hundred. I can't remember now. I should have looked this up before I started talking. It was isolated and put alongside 15 other related viruses that are now categorized as the California serogroup. Okay. 17 viruses, all arthropod-borne, primarily transmitted by mosquitoes. Here's the other ones. Okay, signs and symptoms. Incubation period is 3 to 7 days. Early symptoms phase of 1 to 4 days commonly precedes onset of encephalitis, manifesting as fever, chills, nausea, vomiting, headache, lethargy, and abdominal pain. The encephalitis is characterized by fever, drowsiness, and lack of mental alertness and orientation. So yeah, that sounds right. If your brain is all swollen, you're not going to be cognitively functioning at your best. Seizures occur in 50% of children. Focal motor abnormalities and paralysis, irregular and abnormal reflexes develop in 20% of children. 10% of patients develop coma. The total duration of the illness rarely exceeds 10 to 14 days. But in 20%, there may be recurrent unprovoked seizures. May occur even after the illness is passed. This develops in 20%, especially those who had seizures during the acute illness. In adults, infection is asymptomatic, which means that the patient is a carrier of the infection but experiences no symptoms or only mild feverish illness. Mortality rate is less than 1%, and most patients with encephalitis clinical symptoms recover completely. But up to 20% of patients develop behavioral problems or recurrent seizures. So a little bit more about just how it spreads, what it actually does. Treatments are given. Corticosteroids used to reduce brain swelling and inflammation. Sedatives may be needed, acetaminophen, anticonvulsants to prevent seizures. If brain function is severely affected, interventions like physical therapy and speech therapy may be needed after the illness is controlled. Okay, I don't know why he's getting antibiotics for a viral infection, right? That doesn't make sense. Antibiotics are for bacterial infections. You would need some type of antiviral treatment to work on this virus. You guys, this is just like a very, big overview. Okay, now this says 75 cases reported per year. So maybe getting a little bit more common. Highest occurrence in the Midwestern states. Outdoor activities, especially in woodland areas, are associated with an increased risk of infection. So yeah, this is a very general overview, but I think even from this, it's hopefully a little clear, like why this is so strange. This is a strange explanation because, okay, behavioral problems can persist in 20% of people. Does that mean psychosis? One word we didn't see all over that entire description was psychosis. Now, it's certainly plausible to me that when your brain swells in an acute affection, yeah, you might see things, you might experience delusions, you might hallucinate, you might have psychotic types of experiences. But it's not clear to me why those might persist, or even if they do, after the acute phase of the infection is gone and your brain is no longer swollen. It goes back to normal. I'm not ruling out that it can't happen. It's just that there's no description of that. And so this is weird, guys. It's weird. It's weird. What a weird thing to be making up. But none of it seems to make a lot of sense. It really doesn't. Why is he getting antibiotics for this, if this is what it is? So this is why I would like to have this hearing on the death penalty. It might not get us any more information if they can't talk about this sealed psych exam in open court, and that's really the big question. That's what I want to know. What's the deal with the mental health situation? Is there a diagnosis? What is it? Does it have any, is this California encephalitis thing legit? Is it something totally different? If it's something totally different, why was he talking about California encephalitis at his deposition right before the shooting? Almost like he'd already kind of figured out, what his excuse was going to be. I don't know. That's plausible. It's plausible to me. But Bubby here, who's never been on an airplane or left Letcher County, is Bubby going to come up with California encephalitis? That just seems kind of implausible too. It's like the impossible case where nothing makes sense. Nothing makes sense. So yeah, if the motion to exclude the death penalty requires a certain diagnosis, and I should pull that up too. Forget the number of the bill, of course. Kentucky. See if I can find it. HB, okay, here it is. HB 269. Let's see what I can find out. Okay. Determination. Let me find. Okay, here's the main statute. I'll just pull this up. So I'm probably going to have to work my way through a couple of them. But this way, I think, let me get this bigger, we can see. So a defendant with a serious intellectual disability or serious mental illness is not subject to execution. Okay, so this is going to be the statute we want here, 135. There's a procedure that's used to figure that out. They can be sentenced to anything else, but not to death. Applies only to trials commenced, but that will apply to our trial. So let me see if I can. Here's the determination. At least here's those timelines. At least 120 days before trial, the defense shall file a motion with the court wherein the defendant may allege that he or she is a defendant with a serious intellectual disability or a defendant with serious mental illness. And the determination needs to be made at least 90 days before the trial. So those were the time frames that we were worried about. The decision has to be made in the record. Pretrial determination shall not preclude the defendant from raising any legal defense during the trial. So this doesn't say specifically what serious mental illness is. This one, here it is. Here it is. Here's what he's got to have. Here's what he's got to have. Schizophrenia, schizoaffective disorder, bipolar disorder, or delusional disorder. That's it. But maybe not, because it says one or more. I guess it means anyone or two or three or all four of these diagnoses he has to have. It's very strange language. Trying to work my way through this here. At the time of the offense, he or she has active symptoms and a documented history, including a diagnosis of one or more of the following mental disorders. So this would seem to preclude him from being able to use this defense if he had a disease at the time, but it was not diagnosed, even if he was symptomatic, because it requires active symptoms and a documented history at the time of the offense. Haven't heard anything about him having a pre-existing diagnosis for a mental health condition. Now, what Sherri was describing does sound pretty manic. This sounds really consistent with bipolar disorder. You get in these manic stages, you can't sleep, super common. Get paranoid, get fixated on certain things. Seen this cycle many times. So maybe, maybe the California encephalitis thing is a red herring. Maybe Mickey really has bipolar disorder. But if he didn't have a diagnosis of bipolar at the time that he shot the judge, it's not clear he's going to be able to use this defense. It's not manifested primarily by repeated criminal conduct or attributable solely to the acute effects of the voluntary use of alcohol or other drugs. You can't, basically this is meth psychosis. You can't rely on meth psychosis or, I was really drunk, I was really drunk and that's when my schizophrenia comes out, something like that. I don't know. You can't use that. But I think a delusional disorder as a result of like meth psychosis, yeah, that's not going to work either. That's going to be ruled out. I'm just bringing that up as a hypothetical, not because that's an issue in the case. Oh, so still so many questions here. Still so many questions. Don't know at all about this one. I see CH has been giving me all kinds of good information here in the chat. Lacrosse, while Letcher County, Kentucky is located within the broader Appalachian endemic region, confirmed human cases are uncommon. Yeah, I'm not surprised. Not surprised by that. It's a hogwash of a defense. I don't know. I don't know if it is, because they seem to have a psychologist in their corner. That's not it's not somebody they had to go out and handpick. They didn't even have any say in it. It's the person from the state hospital. Apparently has favorable things for Mickey because he really wants to use it and the state really wants to get a second opinion. So I don't know. I'm so baffled. Yes. This whole situation is wild. Oh, hey, sometimes antibiotics are given to prevent secondary infections. Good to know. That makes sense. That does make some sense. But I wouldn't expect, maybe you can help. I wouldn't expect you to do this long term, right? You wouldn't do that long term. She made it sound like he's been on antibiotics like for years. She said, what did she say exactly? Let me find it. He's always had to take antibiotics every day because he has the infection. Always had to take antibiotics every day. I mean, it sounds like, if nothing else, a long-term thing. That can't be good for you. Oh my God, the antibiotics, they kill your gut biome. That's like the first thing that comes to my mind. Your gut is not healthy if you spent years on antibiotics. Maybe that goes hand in hand with all his health issues he has. I don't know. This is definitely, definitely makes sense to me that if you're at risk of infection, then You know, it's why they give people preventatives, you know, send you home from the hospital and give you, give you a course of antibiotics, but it's usually like a course. I don't know. I don't know what to make of this. Okay, Jeff found Speak Your Piece. We're gonna just have to go look at that real quick because that was too much fun hearing that described. Let's get a feel for what Speak Your Piece on the Mountain Eagle is all about. Okay, here's the June 3rd. It looks like they run this weekly. Speak your piece. Tell us what's on your mind. No need to give your name. Okay. To the guy who won the office of magistrate in District 1, I don't know you. Do you ever go to events like the Mountain Heritage Festival? I would have thought I'd have met you there since I go every year. The committee would sure appreciate it. I think it's time the tree trimming company that works for Kentucky Power Company comes to the right-hand fork of Doty Creek and do some trimming. Did I just see a Fleming Neon City contractor tear down private property that belongs to a family member of an employee? Neon spent $90,000 on a building in the flood zone but cannot buy grinders to fix the sewer. This is like reading Greek in some ways. Everybody in Letcher County is in on all of this. I have no idea what this means. I love the Tanglewood Trail. It's a great perk of living in Whitesburg to be able to take a quiet, scenic walk across town. That said, the stretch of trail that runs along the Whitesburg Middle School can be punishing in hot weather because there is no shade at all for half a mile. It would be great if the city could put some canopies over the benches or build a small pavilion. Ideally, for the long term, a row of poplar or maple trees could be planted there. That would make it even nicer. A stretch of trail for half a mile. I just went out to I did a little backpacking trip this week. It was very short, just a overnight, right as I was getting hacked, as it turns out. But I went into the coulee. I went into the coulee, one of the coulees here in the region, they're super cool. The coulees are these areas where this whole area geologically was like lava flow. It's like lava flow on top of lava flow on top of lava flow, and it's a lot of columnar basalt. You know, the lava flows and then it cools and forms in all these different patterns and stuff. The columnar basalts are very, very common here. And so the layers of it mean, different depositions. You have like different layers of columns and stuff like that. And then during the last ice age, there was a major flood over like most of the Northwest, but the glacial Lake Missoula floods, which in geologic terms happened like 2 seconds ago. It was, 10 to 15,000 years ago, not very long at all. But this massive flood happened where a glacier that was holding back a huge lake, it basically melted. And so the lake burst its boundaries, flooded all over this entire part of the country. And it carved out all of these different channels and things like that in the basalts. And so those are the coulees, the channels that are left after those floods. So they're very cool, but also extremely exposed. They are wide open because not a whole lot of stuff grows on basalt. It's pretty rocky, pretty barren. And what is there is basically like what little moisture is left. So there are some lakes in some of the coulees, like the flood water. There's springs that feed some of them. That's a little bit more rare. Some of them are like old flood water that just like stayed there and hasn't like fully evaporated yet. Gets replenished with seasonal rains and things like that. And so you'll get some like greenery, willows and things like that, but not a whole lot of shade. So I don't resonate a ton with no shade for half a mile in your hot weather in Kentucky, because I will raise you my hot weather in the channeled scablands here in Washington, where the trails go on for miles and miles and miles and miles without a tree to be found. Anyway, I bet the guy who bought the white wicker chair while he was in Florida would like to take it back if he knew the family didn't want it. Thank you. What? What on earth is this? The guy, who is the guy? What is the what? And who cares? Who cares? This is crazy. I go to church here in Letcher County with my husband. I know several members of the congregation have heard him raise his voice at me on several occasions. We were not fighting. He was verbally abusing me. Not one person noticed. Not one person asked me if I was okay. Shame on you. I heard that the young man they found buck naked in the middle of the road got some pills from somebody intending Blackie Days. It seems like Blackie Days was also a day for the pill dealers to sell their drugs. Parentheticals here. Congratulations, you just won the prize for most ridiculous comment in many months award. Even if what you say is true, the volunteers working the Blackie Days festival can't be held responsible for what festival visitors do. If such a transaction did take place, it didn't happen on stage or elsewhere in public view. Blackie Days. This I gotta look up. What is Blackie Days? The Blackie Day Festival. Okay. Blackie Day Festival. Okay, it's May 15th and 16th. There will be live music on stage, craft booths, food booths, and cakewalks. So it just happened. This just happened a couple weeks ago this year. It's on Main Street. You can get all the details. Okay, Blackie Day has been ongoing for most years since 1964, originally celebrating the 4th of July in May. Okay, but more recently moved to May to capitalize on the typically better weather. I still don't know why it's Blackie Day. I bet they're not going to tell me on the internet why it's Blackie Day. Oh, good Lord. Well, this has been a fun little rant session here in the Speak Your Piece. So this is the kind of thing that the prosecution isn't real happy about. I agree with the comment about stray animals and clearing out the officials in the courthouse who do nothing about it. Thank God someone said the same thing I have said many times. It is not right for people not to spay and neuter their animals. The county government needs to start making people who abuse their animals go to jail. I have non-conventional opinions, I think, on neuter. Not so much on spay. But yeah, anyway. Go to jail, apparently, if you're concerned about the long-term health of your male dog. Our rights have been violated. I love our president. Our president is doing everything we, the people, voted for him to do. Thank you, Mr. Trump. People call into this just to say this. Like, just to say this. So it gets published. Why are the garbage men in Jenkins so lazy they never take all the garbage? Oh, another opinion. I would like to thank all the people who down Trump and say he is an evil man for taking tax dollars for his planned ballroom. He's doing nothing but making people lose their jobs. It's a shame a certain man brags about the number of lawsuits against him and how he's going to win them all. Why in God's name would you take a drug with all the possible side effects they mention on TV? Why would they put such commercials on TV to begin with? Have you guys seen this ad I'm seeing it everywhere now. I don't know if that's me or my algorithm or what, but it's an ad for tardive. It's like some tardive dyskinesia medication. Do you guys know what tardive dyskinesia is? It's a movement disorder that you get from taking antipsychotics, typically like atypical antipsychotics, the like first gen stuff, real common, Haldol, real common with the tardive dyskinesia. And it's like Parkinsonian type of symptoms. It's very serious side effect of being on many antipsychotic medications. So they have a medication to treat your tardive dyskinesia that you got from your medication, and they are advertising this on TV. Now, it's not like it's against the law for, people with schizophrenia get to watch TV and get to, it's, of course. But it just seems like this must be quite a small market. This can't be a huge market. And why are you advertising this during like my baseball game? I'm with this person on the drug ads. I'm not a fan of the drug commercials. Festival. What's ridiculous is all these other counties around us have about everything they need. I called the animal shelter in Pikeville to get some little kittens taken care of. I was told nobody could help me because Letcher County is responsible for it. Well, there's no animal shelter in Letcher County. We have to go all the way to Perry County. That's ridiculous. All our officials just sit on their thumbs and do nothing about these little animals. Well, you could just find yourself with 5 cats. Did you consider that? Did you consider that option? Build them a whole cat room? That's a possibility. Just putting that out there. Well, so that was a fun little exploration of Speak Your Piece and what all that is about. And what I can't help but notice is there is not a thing in here at all about Mickey Stines. Not a thing. Now, obviously, he hasn't been in court for a while. So not surprising, but June 3rd, 2 days ago, we knew he was going to be back in court. I don't know. Nobody had anything to say. Maybe I'm going to bookmark this. Honestly, I'm going to bookmark this and keep an eye on it for the future. Maybe take a look at next week and see if they have anything to say about Mickey Stines and Speak Your Piece after this hearing. I don't know. This is a wild one, guys. Wild. Oh, Jeff gave me a note here. Blackie Day Festival, annual small town. Okay, it's called that because it's in Blackie, Kentucky. that does give me a little reassurance. But why is Blackie, Kentucky called Blackie, Kentucky? Just want to make sure I get it here. It's a weekend of bluegrass music, craft food booths, cakewalks, community fellowship, pure Appalachian hometown vibes, part of the bigger Mountain Heritage Festival circuit. It's mountain stuff. It's a fun little mountain festival. That does sound fun, honestly. It sounds like a good time. Just maybe not etymologically appropriate, but who knows? It's just named after the town, right? That couldn't be bad. I see Jeannie B has joined us as a member. Welcome to you, Jeannie. Truth, transparency. Hey, Lana, happy summer. Any travel plans? I think you should cover the end of summer trial with Jose Baez and Diane Monash, Florida versus Shanna Gardner. I don't know anything about that one. Haven't watched a Jose Baez trial in quite a long time. Boy, what's the last one I watched? Must have been Zimmerman. Wasn't he Zimmerman? Wasn't he Zimmerman's lawyer back in the day? Don't think I've seen one that he's done since then. Don't know much about this case. I can take a look. I'll tell you, the whole East Coast trial thing, I know it's limiting, but It's the time zone. The time zone thing is a challenge. It's not the end of the world. Obviously, we did it for Karen Reed, but get some early starts. Now, Florida, they do seem to be a little more leisurely with their schedule. They're not on this like be here at 8 o'clock sharp kind of thing. And in fairness to Florida, I do already have Courtney Clinny on my radar. Would be interested in watching that one too if that one ever gets to trial. But I don't know anything about Shanna Gardner, so I will take a note here. And I'll give you a maybe, Lana. I'll give you a maybe. I'll look at it. I'll look at it, see what we got. Summer plans, travel plans, nothing big. Just want to basically do some backpacking at this point. Get some treks in. Nothing too far from home or wild or anything about that. I do have another trip down to California. Of course, I have to. In fact, I got to start getting that finalized because I am still awaiting whether there's going to be any objection to my request to view exhibits in the divorce from hell, and the response is due today. So we're going to see if O'Malice Evans doesn't want me to see the evidence admitted in the trial, and there's a hearing scheduled for that. I think it's June 20 something. So I need to kind of get on getting that trip set up. So that I'll be doing that, but that probably won't be anything bigger. But yeah, we'll see. Got to work that out. And then otherwise, yeah, no, I'm really sticking close to home this year. We've had my grandma's health isn't doing so well. She's deteriorated, quite a bit. She's having heart issues, and so she needs a little bit of extra help, which is good to have. Good to have kind of a family team around to help with, but also, just making sure we get a chance to spend time with her, because none of us get forever, and some of us are, closer to the end than others. So not really trying to go anywhere crazy at this point. That's kind of where things are at for me. We're about to get summer-wise bombarded with our annual apricot situation. Very early this year, the apricots just picked the first of the nearly ripe ones yesterday. So like within a week, we will be buried in apricots, and I'll have all that to deal with. That's always a good summer activity. Potentially criminal, 50,000 K bond. This is like an episode of Justified. Yeah, 50K is insane. Like, I can't believe that they said that with a straight face. I really didn't. I mean, I'm sure that they said 50K because that's what they know they can afford. They can scrape together 50K in cash or property to get him bonded out, and probably still pay for his lawyers and stuff. I don't think he's got a public defender, right? But I don't know how you ask for that with a straight face. It's like a credibility killer right off the bat. No, he's not setting it at 50K for a murder. Even like, not just even if you were crazy, like it kind of especially because if you were crazy, that's a volatility issue. That's an instability concern. That's a just no, not that you need to be detained pre-trial if you've got a mental illness. Not at all. But it just kind of goes along with the seriousness of the crime and the fact that this kind of, by his account, sort of came out of nowhere, even though it also sort of didn't, because he's had California encephalitis, apparently always, and was deteriorating in the days before, but nobody really took it seriously or said anything about it. These are just kind of concerns about the ability to manage it. And if it's putting him in the kind of condition where he's, delusional to the point of killing people, that's a public safety concern. Overwhelming majority of people with delusional disorders are not out killing people. So, not a concern for like the average, but it's kind of always there on the horizon, at least with this one. Yeah, that's a pretty ridiculous ask for me. Okay, Jeff says the town founder named it after his brother, Joseph Blackie Brown. This isn't getting any better. This isn't getting any better. Because why was Joseph Brown's nickname Blackie? Why was his nickname Blackie? I have a relative. I'm not gonna like get into too many details or anything, but I have a relative, an older relative, who is from not Appalachia, but not too far away. Not too far away. Southern Illinois, right on the boundary, right on the border of the Missouri River. From many moons ago. Back when this part of Illinois had like sundown laws, you know, things like that. The parts of town where the black people were allowed to live versus where the white people were allowed to live. You know, serious super racism stuff. Stories about a black dentist in town that you know, the white people generally, you know, wouldn't go to, wouldn't take your kids to, and it was sort of a big deal for this relative because this relative's parents did take them to the black dentist, and this relative really liked the black dentist, and so like from a very early age, this relative was you know, kind of aware of just race and how that played out in their community. But the reason I bring this all up is because this particular relative is somewhat olive-skinned, darker hair, bit of an olive complexion. And this relative was nicknamed Blackie at school. And so, yeah, I'm not feeling real satisfied with this explanation. That all of this is totally fine. The fact that it was just a nickname, Joseph Blackie Brown. I kind of know where those nicknames come from. So, oh, where are we at? This one is saying town was a big, interesting, big coal mining town back in the day, and everyone was literally black from coal dust. So they called the town Blackie. Okay, coal dust works for me. I buy it. That does make sense. Yes, it would make you rather black. Jeff's over here busting my balls, calling to speak your piece and describe your relatives and how they got nicknamed Blackie. Oh, you guys. Yeah. Like black country in the UK, again, coal mining. Okay. You guys are comforting me. These are explanations that I can live with. Yeah. Let's go with coal dust and say no more. It's coal dust. Wink, wink. We're going with it. That's fine. So anyway, thanks chat for keeping me up to speed on all that. Oh, this looks like an interesting one. We have White Ladies Road that activists do not like. Sadly, they know little history of it, as it was named after a road leading to White Ladies Public House. I think White Ladies Public House, named after a field of snowdrops flowers. Yeah, that's a good one. It's like the name of a flower, and people are you know, all getting up in arms. I'm not like trying to be too, you know, wokey or anything like that. I find these things kind of fascinating and just wonder about what's at the roots of that one, and you know, all that. So, but yeah, often not an issue. Not an issue. Well, I think I need a nap. I think I need to recover from this one. Oh, guys, well, still no news from Twitter about getting my account back. So, like I said at the top, not really expecting anything to happen real soon with that. But I do plan to be back here next Friday because we have another Tyler Robinson hearing. This is where we are getting the evidentiary hearing on the defense's motion to basically hold Chris Ballard and Jeff Gray, the prosecuting attorneys, in contempt of the gag order for making the public statements about the ATF report. And then we are also, what's the other thing that we're doing? I need the nap. It's been too early and my mind is spun and I'm still on California encephalitis. There's something else that we are arguing after the order to show cause. And I don't remember what it is. But anyway, there's something else too. So we'll be here next Friday for Tyler Robinson. I have Christie wrapped up. So I will in the coming days, I will be releasing the final episodes of the Christie trial. Very quick verdict that came through, but then a fairly extended sentencing hearing that will be our conclusion. Seeing what Jim got. We know he's convicted of something, but we don't know of what yet. We don't know how bad the situation is in terms of the book being thrown at him. So that's what we wait to find out. I had somebody give me a comment to ask if I could follow up with the appeal as well. And I don't know anything. I don't know if he did appeal. I assume he probably did, but I know nothing about it. So I will be happy to take a look at that and see if there is anything to follow up with as far as any appeal that Jim Martin pursued. Otherwise, that's kind of my plans for now. So if something comes up in the meantime, you know what to do. You know how to find out about it. You won't find out on Twitter right now, but you know how to get the notifications and things like that if I set it up. Probably not going to, but things happen. I did hear that the Aaron Spencer case got dismissed. I don't know all that much about the case, about the status. That's one. Go over to Defense Diaries. They're Bob and Allie have been the kind of leaders on that particular case. I believe there had been a motion filed, so I'm not sure if this was the motion had been granted or the prosecution just voluntarily dismissed or anything like that. I don't know the details, but it's kind of a big deal. That trial is not going to go forward, so I will probably be checking in with Bob and Allie to find out a little bit about what happened with that. But that's some pretty big news. Kind of breaking. It sounds like. What else? Anything else going on that we need to talk about? I already mentioned I've got the thing coming up in the old Alice Evans, waiting to see if they're going to object to me getting copies of the exhibits. Luigi is getting ready to get going in state court. In fact, I think Monday today. I don't remember. Yeah, I think Monday. That starts. So keeping an eye on that. I'm obviously not going to New York for that particular case. The whole thing has just kind of become a big shit show. But I do want to follow it as much as I can, just because it has been very interesting. So I'll be keeping an eye out on that. See if anything happens that we have a good record of what the situation is and stuff like that. We're going to be dependent on fact reporting, but possible transcripts will get released or things like that. What else? I'm just kind of looking through my list. Yeah, Courtney Clenny got kicked down the road again. Not much else, I don't think. Still waiting for news on Afro Man's appeal. See how that one goes forward. Yeah. So nothing else really on the short time horizon. Very possibly maybe something to talk about with Luigi over the next week, but they'll just be doing jury selection, so I kind of doubt it. Otherwise, guys, Friday. What time? What time Friday? Oh, I didn't write it down. It's probably, if I remember right, hang on. I made notes. Yeah, so it'll be 9:00 their time, so it'll be 8:00, 8:00 my time, which means I'll get started at about 7:45 next Friday. Oh, it's the motion. Yes. It's the motion about hearsay. I'm not super excited about that one just because I've mentioned before, this one is, I think, really obviously to everybody, this one is a pro forma motion. Utah law is strictly against them. They're saying under federal law, the Utah law is unconstitutional. May or may not be the case, but it's not going to be the type of call that Judge Graff is going to make. So Judge Graff is going to follow the Utah law that says prosecutors get to use quote unquote reliable hearsay at the preliminary hearing. And the record will be preserved for appeal and post-conviction, but not really expecting anything too surprising or extraordinary there. But we will have the evidentiary hearing on the gag order and the potential contempt. Probably won't get a ruling again from the bench, but he's been a fairly hot bench when we've watched the arguments and stuff like that. You know, he does have his say, has his questions and things like that. So that I think we'll be interested to see. My money on this one is that he is either not going to find a violation, he's going to find that the state stayed within the lines, or I think maybe more likely, he's going to find that they did violate it, but that it was not willful and therefore not warranting, you know, some type of a sanction. The reason why I think this is because the comments were a little bit in the gray area. So if they didn't strictly comply with the gag order, then they didn't comply. Comments are a little bit in the gray area, but he's not going to want to like rock the boat super hard, I wouldn't think. Not just for this particular case, but you know, the personnel. These are the prosecutors in his court. He doesn't want to spank them unless they really deserve it. Is this the worst thing they could have done? Definitely not. You know, they certainly could have said a lot worse things. Levitt case that they've been relying on with all that example of the prosecutor saying much worse things than the prosecutors here said. But he also wants to discourage any public statements. I mean, that's the whole point of the gag order. And so it's I think going to be interesting to see how and to what extent he chooses to police that order that he put into place. I think it's unlikely there's going to be any kind of serious consequence for it, but he could decide, you know, hey, I really, really want everybody to shut up, and so I need to set an example. Don't know. That's going to be what we need to find out. So anyway, that's what will be on the docket for Friday, and I will be back then. So let's see here. Feed your bubbies, Jeff says. Lizika has sent a super sticker. Thank you so much for that. Really do appreciate your support. See if there is anything else. Yeah, the Mountain Eagle, definitely. They have a whole column on hearsay. Oh, that thing was wild. That thing was wild. Has Andrea heard about all the Proctor texts? I'm sure she would be floored. If there is something new with Proctor texts, I haven't heard yet. So I will run to the Googles and see if there is something new about Proctor texts. What I knew, because I haven't really been following the civil trial. It's all kind of exploded. It's gotten big and a bit convoluted, and it's civil. I don't love following civil cases, kind of period, as a general rule. Obviously not a universal thing. I will look at them, but just in terms of like following them in depth, through the whole case, civil cases are a bunch of discovery disputes. 99% of the time, it's a bunch of super obnoxious people arguing about what needs to be produced and what doesn't, and pointing the fingers at each other, and arguing like people have just committed capital sins because of how they answered an interrogatory or something like that. It's too much for me. I can't handle it. It's histrionic. It's obnoxious. I don't like it. So I don't always follow a lot of civil cases real closely. And that applies to Karen Reed's case as well, which I understand is also now like a Turtle Boy case and a counterclaim, and all this other stuff is going on with it. But what I am familiar with is that there was like another Proctor phone, and Rosemary Scapicchio has been kind of at the forefront of trying to get that and get it released and stuff. So if there's something new, I expect maybe has to do with that. Oh yeah. Oh yes. New Proctor stuff. Lawyer, covered it yesterday. Karen Reed filing. All right, guys. All right. Oof. Don't eat before you read the lawsuit. The texts are so very bad. Yeah. Yeah. Oof. Hold on to your hat when you read those new exposed texts. I'm not surprised. I mean, yeah, this is pretty much my view about it too. Nothing about Proctor surprises me anymore. No, my expectations are in the basement. They're in like the bunker below the basement. I don't have any expectations for him. What I am interested in is kind of the broader ripple. Like, who is he saying these things to? What does this say about the bigger culture? We already know Tully got having my my nap thing. Maybe I have California encephalitis, disciplined. He got disciplined for failing to supervise. But Yuri didn't. And wasn't Yuri his direct supervisor? Anyway, that's really all that, most of what interests me about the situation is just the bigger implications of it. And yeah, what does it say about this culture here in this area that we already know is a big problem? Not just from what they did to Karen Reed, but how they handled the Sandra Birchmore case. Seems like if cops are involved in wrongdoing, they're going to do everything they possibly can to back away and see nothing and cover it up, shut the door, etc. How much are all of them implicated in it? That's kind of what I want to know. So I will go and check that out. CH, I've only read a few of the texts. The rampant racism is horrific. That doesn't surprise me either. In fact, I'm pretty sure Rosemary Scapicchio had kind of, I don't think she quoted anything that I remember, but I just remember a comment from her to the extent that like it's clearly racist, a lot of racist stuff. So that does not surprise me either. I guarantee you never would have expected these texts. All right, guys. Well, maybe I need to do a react. Maybe I need to set up a live and we can read through these texts and do a react. I don't know. How's our weather this weekend? Don't know if I'm gonna want to be outside the whole time or what, but I'll look into that. That seems like a good idea. Yeah, Sergeant Good resigned just before the texts were made public. I do remember that. I remembered that. Not clear to me if there was a link. is like, is he part of the text? Is he involved in it? Good was always like one of the sort of dark horse ones in the Karen Reed trial, because like there was nothing real solid on him as being, you know, part of the cover up, part of the hoax. But there were certainly reasons to be suspicious of him. There was that weird comment during Carrie Roberts's call to the station where they talked about the Blizzard party. And so it kind of seemed like maybe they already knew about this get together at the Alberts house. The fact that he was the one on shift in the first place when, for example, Higgins came back into the station. So Good was always a little bit of a he's like on the edge of all this, but his full like involvement and complicity not necessarily that clear. But I am very, very curious. Normalize taking bad cops' pensions. Yeah. Yeah, seriously. That's the part where I just finished reading another book. I finished reading About Face. I started reading About Face like months ago, and I had to put it down because it was boring me to tears. But I finally picked it back up and finished it. About Face is written by this guy, Colonel David Hackworth, and it was an interesting read in many levels. Hackworth was one of the last like battlefield commissioned officers. Like they don't do battlefield commissions anymore. But so he got a battlefield commission in Korea, and he was serving in Korea. He is like one of the most decorated soldiers in America. He's got 10 silver stars, all kinds of Purple Hearts, just like all of the big awards. And he kind of got himself in trouble when he started speaking out about the Vietnam War during Vietnam in like 69 or 70, somewhere in that ballpark, and ended up, leaving the military and going on to civilian life. So this is his book that he wrote like about his life. And it was interesting, very interesting from a story kind of standpoint. Very interesting life this guy had. He, basically lied at 14 to get into the Merchant Marines at the end of World War II, and then ended up in Italy with the army, and then Korea, and then Vietnam, and always kind of like moving up through the levels of the military. And so through that, he saw kind of how the military works from an operational administrative kind of standpoint, and who ends up in positions of power and why. And most of the time, one of his big beefs was that the things that tend to put somebody in line like to be a general are not the kinds of things that would make them good on a battlefield. That in the army politics, the types of traits that produced like a General Patton back in World War II, they would absolutely not be tolerated. That person would be, sort of nudged out of any kind of advancement in the army. So a lot about like the politics, and also the self-serving nature of how a lot of the military decision making happens, because people are advancing their careers, not necessarily like furthering any kind of strategic mission or looking out for the men on the ground or anything like that. Like if there's a conflict between, I might get to be a general someday versus, I might get to save some of my troops, they're going to go with what makes him a general. And that was a big part of his complaint. He was like the, kind of considered the guy who always had the troops first. And the reason why this reminded me of it is because this is the type of thing he really hated the defense contractor revolving door. You know, people do their military career. You retire as like a, you know, 3-star general. You get $50,000 a year pension, you know, for life. But then you go on and you work for a military contractor, and so the cultivation of that already starts to happen while they're in the military. And he blamed that for things like, you know, equipment, like bad equipment, you know, equipment that's not fully vetted, all the bugs aren't worked out, things like that. But it's making it onto the battlefield because it's getting endorsed by these people who are forming their relationships with the company in the expectation that I'm going to, you know, I'm going to retire, get my pension, and then I'll come work for you guys. So he was advocating for like a you know, a law that would take away the Army pension for people who go on to work for the defense contractor, just as a way to try to, you know, realign the incentives with the actual benefit of the people on the ground. It's not quite the same scenario, but it certainly would work, wouldn't it? Would not be a hard law to pass, I wouldn't think, to take away somebody's pension. So the implication of it is potentially a takings issue. That's where legally speaking, there's possible hurdles. Because if they were hired as a cop under a certain expectation, you know, of pensions, this was promised to them as part of their condition of employment, and they vested in that, then taking away a vested right can be considered a deprivation of a property interest for takings purposes. But you could certainly always make a law that applies to people in the future. From now on, we are not going to give anybody a pension if they are, you know, removed from the force for any reason, or, you know, for X, Y, and Z findings that are made about their conduct. There's things like that could be done. Part of just an aside about the About Facebook. I'm reading through this book, and like I said, I got kind of stuck in the middle of it because it was after he got his commission, and so he ends up in the officer class, and before this point, it's been like this great war story, you know, and then it starts to turn into the army staff and all of the acronyms and the trainings that they go to, and the this and that, and so I was just sort of drowning in like the army bureaucracy, and couldn't get back into it. But I finally did finish it, and I'm glad that I did, because by the end of this book, I get through this book and I realize, like, just crystal clear, this is another Dr. Fallon, guys. David Ackworth, he's another one of these, like, not really malignant, but really strong psychopathic tendency kind of people. And so I was going down a little bit of a rabbit hole, because you guys know I love this, you know, psychopathy rabbit hole. And I learned there is a whole, like, sort of theory that's I don't think it's like generally adopted, generally accepted yet, but it's kind of being explored. General theory of psychopathy that has it kind of reorganized around different sorts of traits and characteristics, and they have these grouped as what they call fearless dominance characteristics. And so these are psychopathic traits that involve things like low stress, you know, there's no anxiety, very positive emotion, they feel great all the time, very extroverted, life of the party kinds of stuff. There were some other features that of psychopathy that go along with the fearless dominance, and then the other part of it that they talked about was self-centered impulsivity. And so these are the traits like the irritability, the callousness, you know, stuff like that. And so it kind of seems to be this way to, it's like developing in part to respond to grapple with this issue of the people like the Dr. Fallons, who are like, he has that brain. Okay. He has the brain. He is biologically indistinguishable from the psychopaths who are in prison, who have murdered lots of people, but he hasn't murdered lots of people. He is, in fact, at least generally contributing positively to society. Oh, sure, there's a little bit of detritus along the way because he's not real good at personal relationships and stuff like that. Doesn't treat his wife and kids very well, kind of thing. Real common ground with Mr. Hackworth there. But he's not doing this antisocial kinds of stuff. And so I'm just sort of fascinated by this because Hackworth really seems to fit this model, the fearless dominance without so much of these other like antisocial. It's still there, right? He still like doesn't give a shit about the regulations. Will kind of do, what he thinks needs to be done regardless. Doesn't treat people very well, does manipulate people, does expose people to risk unnecessarily, things like that. Same kind of stuff as Dr. Fallon, but just not to such the extreme as the people who end up in prison. So I'm very interested in that dynamic. I'm probably going to be diving down that rabbit hole a bit more, just to see, what's the state of that theory. It comes out of a test that's the PPI, the Psychopathic Personality Inventory. So people who've heard about psychopathy have definitely heard about Hare's checklist. This is the forensic tool that's most commonly used to look for psychopathy in like prison populations and stuff like that. But so the PPI was developed very specifically for people not in prison. And so it's supposed to capture a lot more of the people like the Dr. Fallons and possibly the David Hackworths, who have a lot of the characteristics, except for the part where they're severely antisocial and damaging to the fabric of their community. Interesting stuff. Very very fascinated with that, but it certainly lines up with the idea that I've been kind of grappling with for a while too, of like, how does this work from an evolutionary standpoint? If being psychopathic was all bad, then you would think that the traits would have disappeared. They wouldn't promote survival, but that doesn't seem to be the case. The traits get passed down, consistently. We consistently have, so much of the population with these types of characteristics after many thousands of years of evolution. So it suggests that something about them is beneficial. There's a reason why they persist, even though they're like anti-altruistic. And so, part of the theory is because you need these traits to fulfill certain functions. And if there is one function I can think of off the top of my head, we're like, yeah, you might want a psychopath to do that. It's out killing people in your wars. Of course, that's who you want. Of course, that's who you would want. People who aren't going to stress about it. They are going to be fearless. They're not going to be all stressed in the face of danger. They aren't going to be conscience ridden. They aren't going to wake up in the middle of the night haunted by the things that they've done. That's going to be your best soldier. So I don't know. It lined up for me. It was consistent. It was consistent. Anyway, that was never done the whole book club thing, but of course you guys know I like to talk about the stuff I've been reading, and that was my latest. So it was CHC has an article that discusses what I'm talking about. Yeah. I can't write down that whole, but I'll come back to it and check it out. So, yes, we will close with this, guys. I know the Twitter is hacked. I know it's happened again, and this was not anything that I can identify that I did myself this time. Like the first time it was phishing scam. It was very obvious. This time it's not clear. And that's what's a little bit alarming to me, because I had the two-factor authentication on, and somehow they were able to get past that. So they have, it seems like, some kind of backdoor, into my account. Doesn't give me a lot of optimism in terms of being able to like permanently secure it, but we'll give it a shot. We'll give it a shot. So I'm sitting there in the Twitter service queue. They know about it, filed the report. You can't file multiple reports because they'll just tell you, you've already filed a report on this. So so I sit and wait until Twitter decides to try to help me out. And last time it took about 2 weeks. So not expecting things to be resolved as soon as I snap my fingers. Yeah, the upside of psychopathy and leadership, fearless dominance. Yeah, the fearless dominance stuff. It really is fascinating. So I'll probably be looking more down that, looking down that rabbit hole in the near future. Is it the same people who hacked us last time? I don't know if it's the same people, but they're following the same pattern. It's crypto hackers trying to use my account to promote crypto scams. I understand they are DMing the people in my contacts with the phishing scam, which is the same thing, that happened last time. So yeah, I'm pretty suspicious it's the same people. But of course can't say for sure because they just use some spoofed email address, and it's a different one every time. So can't identify them that way or anything. But Arizona Ashley, I'm permanently locked out of my Twitter. It's fine. It is fine. Like, I'm not really that stressed about it because it's just freaking Twitter, right? It's not like anything I need to get upset about. It's Twitter. Oh no, if I can't read Twitter again, it's hardly the end of the world. It would be a minor inconvenience because yeah, I do get a lot of information about stuff like, oh, did Procter have some new text come out or something like that? I find out a lot of that stuff from Twitter, but it's not like there aren't other ways to get information. So if that happens, it happens and it's fine and I'm at peace with it, but I am making the effort to try to get it back. So we'll just see how it goes. But what if we want cat pictures? Then you need to go to Instagram. Generally speaking, Instagram is going to be more of the picture place anyway. I have some cat pictures up there, probably not enough. There's probably never enough cat pictures, but I could, especially if I don't have Twitter, I could maybe make more of a commitment to share the cats over there on Instagram. So that's the solution to that one, at least until the hackers find their way into Meta too. Don't know if that will happen, but yeah, it is what it is. That's like I said, it's not the end of the world. It's an inconvenience, but just got to be patient and see if it's going to get fixed or not. Ooh, somebody says they've gone to Threads because Twitter, Ali Hoffer. Twitter is just unusable for me at this point. It's so bad. I get it. Twitter's been a cesspool for a long time. Everything kind of keeps changing too in terms of like the algorithm and what it feeds you and what it doesn't. Obviously, you can always just look at your own, following, but I never do. I've always, I don't know. I let the algorithm feed me stuff, but it is sort of interesting to see too what it chooses. There was a period that I really enjoyed. I really enjoyed it where, Twitter figured out that I'm into Chile. And so it was feeding, serving me up all of these posts from Chile and about Chile and like about politics and about all these different things going on. And it was fascinating. I loved it. And then just kind of like, I'm clicking on everything, right? I'm like, yes, feed me more of this stuff. But then it just kind of stopped. And for some reason, the algo hasn't been feeding me Chile lately. So I don't know if it's something changed or what, but just kind of inconsistent and unreliable what you get through Twitter. Oh, another crypto post 20 minutes ago. Yeah, they're busy. They're busy. So yeah, using Gus did make it a little personal, didn't it? I didn't like that either. Motherfuckers. I'm gonna get my Twitter back. Well, we'll see. Guys, I think it is time for me to take the little nap. It's been a minute. Been an early morning. I guess it's already lunchtime. Sometimes I get talking and just don't even realize how long the stream has been. How to tell one had a legal career. The ability to talk endlessly and not really know that it's happening. Well, interesting day today, wild day. I've got some notes about the things to follow up on. Lana, I will look at Shanna Gardner and see if that's a case I want to follow. I will see what I can find out about these Proctor texts and I'm thinking it might be fun to do a live to just react to them before I've read them, but I got to like explore how to find out like what's there without getting spoiled on what it is, I don't know. We'll see, but I'll take a peek at that. Anything else comes up in the meantime, best place to find me, again, Instagram is pretty good. You can at least request to DM me there, or Substack also, they have a messages system there, so you can find me there and shoot me something if you're like, Andrew, you absolutely must pay attention to this thing, it's huge, and I may or may not, but never hurts to give it a shot, because there's tons of stuff out there and a lot of it is super interesting and not all of it's gonna be on my radar. So you find something that you think is neat that might be cool to talk about, by all means let me know, and if I agree, then we'll pick it up and we'll run with it. Friday, guys, otherwise, unless you hear otherwise, Friday the 12th, 7:45 Pacific time, we will be coming back for more Tyler Robinson, and I'll keep an eye out for the rulings in this case. I'm sure it will be Mountaintop Media that I'll hear it from first. Should be getting written orders, and then like you said, some more hearings on what still needs to be resolved. So we will kind of take it as we hear it, but I'll be keeping an eye out for any more updates so we can figure out what the hell is going on over here in Letcher County. What's the deal with this story? Is this guy like the smartest idiot who has ever existed, or is this actually highly sounds crazy implausible thing actually true? I don't know. It's an uncomfortable feeling for me. Usually I feel, pretty confident being able to at least have a lean one way or the other. And I just don't have that in this case. I really don't know. I lean myself into, it's malingering because this whole thing sounds like bullshit. But then I talk myself out of it. How is this guy coming up with that as his bullshit story? I don't know. Eager to find out though. So we're going to call it a day, guys. Thanks for being here. Appreciate the company. Kind of needed a hand to hold on this ride. This was like jerking me back into Wild West court. Like we've been in lately in courts that just seem so professional. I know I am still apparently the minority opinion with like this Tyler Robinson case. Honestly, this is like some of the most professional judging and prosecuting and defending and the collegial relationship and everything that I've seen in ages. These prosecutors seem so good to work with. The judge seems so good to appear in front of. He seems so fair. He's so calm. He's so nice. And I've kind of gotten acclimated to that. And it has maybe gotten me out of the vibe of yeah, how different things can be in other places. So I got a little recovery to do from today's session, but Bubby, I'm not going to get over Bubby. I'm not going to get over Bubby. I think that was the big takeaway from today, I think. Is Bubby and his mommy bones. I think we already knew about the mommy bones from one of the pleadings, but I didn't know about Bubby. So yeah, we'll wait to see how things develop with old Bubby Stines' case. I will let you know when I have more information and more stuff to talk about. Guys, thank you, mods. As always, CH has been like just a great resource with the links and the information and all that stuff. You're able to like, oh, I know what she's talking about and flesh it out and find good information for us. I saw Moon Goddess coming through the chat. Of course, Forensic Fuhrer, you guys really, really appreciate you and everything you do to keep this place running smoothly. Not that I think Mickey Stines is maybe the chaos that certain other cases can tend to be, but you never know. It's important to have a good crew around keeping an eye on stuff. So yeah, been a fun one. Gonna let it simmer. Gonna go back to read more of the Speak Your Piece in the coming days. might have to make that a regular check-in, but I will be interested to see if next week there's any anonymous call-ins about Mickey Stines. We'll see. So with that, guys, enjoy your days. What's left of them. I still got a lot of day left, but I know those of you over to the East Coast are getting towards the end of your day, the end of your Friday at that. Friday in summer. We're just at like getting to that peak of the days being so long, so energizing. There's just so much to do. You get off of work and there's still hours of daylight left. Just like, how could you not be inspired and energized? And I don't know, could be just me, but I really feel like this is a good time of year. We're not suffering in the heat yet, most of us probably, but yeah, we get all those upsides. The gardens are starting to bloom, and yeah, it's a good time. And it's Friday. It's almost the weekend. So yeah, a lot to be happy about right now. A lot to kind of celebrate. Maybe not necessarily in a big way, maybe even just in a small personal gratitude kind of way. But who isn't glad for a Friday afternoon in early summer? Maybe school's out. Yeah. This is the life, guys. This is where it's at. So I'll be back next Friday, unless you hear from me sooner. May or may not be on Twitter by then. We'll just all see how it unfolds. It'll work out one way or the other. It always does. So thank you again, guys, for joining me. Thank you, mods. Thank you, everybody. I will be back soon and appreciate you all. See you next time.